when you don't understand this after reading number of times, not reading once or twice. Now, coming back to policy. Policy violations you have seen. When the policy is violated and the third party, some person suffers a risk. వాడికి ఎవడో లారీ బస్సు వస్తూ ఉంది, వాడు నడుస్తూ ఉంటే వాడికి గుద్దారు, అతనికి దెబ్బలు తగిలి రేపు పొద్దున కోర్టు ముందుకు వచ్చినప్పుడు ఏమండి ఈ లారీ అతనికి డ్రైవర్కి లైసెన్స్ లేదు కాబట్టి నేను కట్టాల్సిన అవసరం లేదు అంటారు ఇన్సూరెన్స్ కంపెనీ. కానీ క్లైమెంట్కి వాడి లారీ గుద్దేటప్పుడు నీకు లైసెన్స్ ఉందా అని అడిగి గుద్దించుకుంటారా? దట్ ఈస్ వాట్ యూ షుడ్ అనలైజ్. mere argument is not argument. ఒకటండి, శతగాత్రుడు దెబ్బలు దగ్గర ఉన్నారు, కుటుంబం ఛద్రమైపోయింది. ఇన్సూరెన్స్ కంపెనీ మే సే that we are not liable to pay the compensation as there is a violation of the policy. Only to that extent your argument can be. You can't say he is not entitled. Who are you to say that? What right has insurance company to say that they are not entitled for compensation? No, it cannot be. I stand for insurance companies, still I support this. It is only you can say, sir, I am not liable to pay compensation because there is a violation of the conditions of the policy. Then came this pay and recover case. He is the third party. That innocent man do not know whether there is a license or not, permit or not, whatever it be, whether he is racing or doing some nonsense. You pay him. The policy is violated by the person who is in contract with you. Go and collect it. And there are also judgments of Supreme Court where they said, first, tribunal shall take guarantee from the owner of the vehicle to the extent that is disposed to be paid to the victims. Subsequently, that was not modified, but that was not being followed. That remains as it is. It is not followed by others. Now, again coming to policy. This is why I am discussing about more on policy. The entire claim or the compensation is based on the policy. Unauthorized passengers. Who are unauthorized passengers? Yes. One, persons, as far as insurance company is concerned, persons whose risk is not covered under the policy of insurance. But general notion is concerned, persons not permitted to travel in accordance with law. Here I am talking as an insurance company advocate, I am talking only to the extent of liability. But there, yes, what if they travel as unauthorized passengers? Owner, your driver permitted him to get into a transport vehicle. Either you collected money, you did not collect money, is the second aspect. You permitted them to travel in your vehicle where the permit, they are not, there is no permit for them to allow to the vehicle. So you pay the compensation. There the pay and recovery theory will not apply. And it is not a violation of policy, my friends. It is no policy. Why no policy? To the extent of policy, we go to a hotel, we take a ticket for plate meals. We go there and we see some varieties of dishes around. We ask them. They say, so sir, you took only this much and we'll give you this much. Adi unda kada bhojaname kada? No. It cannot be because you cannot pay for it. And we are not liable to serve you with that. Same. there is no policy. There is no ticket for you to serve those items. Violation of policy is only on these aspects which I discussed that are mentioned in 149(2) in the earlier Act or 150 in the amended Act. And as for unauthorized passengers is concerned, there is no policy. So there is no policy covering that risk. No policy in the sense not that. Now, before the trial court, earlier we had that a permission under 170 of Motor Vehicles Act is required to question the negligence aspect and quantum aspect. No, that is clarified. That is clarified because it was there. That was only non-understanding the provision of 170. 170 is clearly understood. If he is a party to the insurance company, is a party to the proceedings, when he is a party to the proceedings, against why make an application and taking defense in asking for a leave for a defense? That cannot be. If he is a noticee, then he must make an application before the court saying, sir, I am the insurer of that vehicle and there cannot be any compensation without being an opportunity given to me. So please grant me permission as required under 170 of Motor Vehicles Act. There were many cases that were struck down because there was no 170. After we clarified by the Supreme Court, now at times there will be a question, what about 170? But nobody is serious on that because it's no longer a requirement. Trial matters are concerned. Trial matters are concerned. When we are approaching the tribunal, asking for compensation, when we are making a claim for compensation, what we plead must be the same in our request before the court. Recently, we have been coming across many claims where you claim 5 lakhs, the court makes a calculation of 15 lakhs and says you are entitled for 15 lakhs. And in some cases, courts say you claim 5 lakhs, so I am awarding 5 lakhs, though you are entitled for 15 lakhs. Then the question arose in appeal, some judges made a question. How are you entitled for more money when you are not aggrieved? Yes, but you must raise, that's what brother. Some courts are serious on this aspect, being when you are not aggrieved, where is that? What you asked is paid to you. You asked 5 lakhs and they paid you 5 lakhs. How are you agreed of it? This is the question arose. Of course, the judgments are passed, but the arguments, say, what I request all the friends while making the claim application, make the calculation in advance, a clear calculation. A lakh, that was this way, that will not count, but, and insurance companies, who take the difference under 149 to our present 150 subsection 2, or who take the defense that the workers are, persons are unauthorized passengers. This dispute, when giving evidence before the court, what they say in the written statement will not be the same before the court in evidence. They take the defense that she is an unauthorized passenger, and coming to the court, they say they don't have a driving license. Or they take common defense of driving license that the driver is not having a valid and effective driving license, and the evidence would be that he is an unauthorized passenger. Friends, whatever the defense taken or whatever the pleadings for claiming compensation, everything must be supported by a doctor. Supreme Court recently also said, let this being a summary trial. How can it be a summary trial when you are opposing it? When you say I am not liable to pay, you have to prove. Summary trial అంటే వచ్చామండి నా దెబ్బలు తగింది, ఇది నాకు ఇంత ఖర్చు అయింది, నాకు ఇంత నష్టం జరిగింది, ఆ డబ్బులు ఇప్పించమంటే ఎస్ అంటారు. కానీ యువతలు ఇన్సూరెన్స్ కంపెనీకి వచ్చి వైలేషన్స్ ఇన్ని ఉన్నాయండి, ఇవన్నీ చేయడానికి లేదు, అతను నేనేం కట్టాల్సిన పని లేదు అంటే సమ్మరీ ట్రయల్ కింద ఎట్లా వస్తుంది? మారిపోయింది కదా. ఇవన్నీ సున్నితమైన అంశాలు. ఇట్లా చెయ్యండి కరవమంటే కప్ప కోపము, వదవమంటే పాము కోపము. ఇట్లా చేయండి అంటే నేను క్లైమెంట్స్ ఇదేంటి వాడిని శుభ్రంగా చేసుకోమంటే వీళ్ళు ఎట్లా చేస్తున్నారంటారు. ఇన్సూరెన్స్ కంపెనీ వెళ్ళాం, మా వైలేషన్స్ దాన్ని ఏమైపోవాలి, మేము ఎక్కడి నుంచి డబ్బులు కట్టాలి. ఈ మధ్య కాలంలో now we are experiencing another difficulty after 22 with regard to making of claim. Earlier there was no limitation till 31st March 2022. Anyone can make a claim at any point of time after any long time. Now after 1/4/2022, after the amendment, they say you should file an application within 6 months. How can we file an application within 6 months? One, it is all the claim must be supported by documents. This issue has come before Kerala High Court. Kerala High Court condoned the delay and they permitted. And the matter is again carried to Supreme Court, which is pending. But this particular aspect of limitation, I think Supreme Court only will have to answer this. Now this was a question on being required to be addressed by the Supreme Court itself. Undoubtedly, 6 months period. In Workmen Compensation Act, it is 2 years. ఇక్కడ అసలు లేదు. అట్లాంటిది restricting 6 months, you don't get a document. In some hospitals, sir, they don't give certificates. No, this is to be done. I think only the insurance companies went on this aspect to the Supreme Court. There must be the combined somewhere unity among the claimants advocates also when addressing these. Insurance companies, they are rich enough to contest all these things. Because there are a number of people, 40-50 companies, and peanuts for them in engagement with the claimants advocates. This area is one to be addressed. If required, let there be addressing of letters to the Ministry of Law and the Prime Minister's Office. Will this work out is a question. I'll tell you from my personal experience. Though I appear for the insurance company, I have something very particular on this 147 and 149 too. That is not good law. So one evening, I was opening the laptop. I found a page, Prime Minister's page, which said, write something to the Prime Minister, some grievance of yours. Some grievance of yours. I just wrote something. In some 10 days, I received letters. I received email from the Prime Minister's office saying that your grievance is forwarded to Surface Transport Ministry and Law Ministry. After 10 days, I received 2 emails from Surface Transport and the Law Ministry. After some time, a friend of mine called me and said, did you see the amendment of Motor Vehicles Act? I said no. Then he forwarded me in an email. My grievance was addressed. Provided that a policy is not required, is removed. In a new act, you don't find it. I have a very strong grievance on it. అసలు ఉండవలసింది ఉన్న తర్వాత అది రిక్వైర్డ్ కాదు అంటే ఎన్ని పెడర్థాలు వస్తాయి కదా. Why I am telling this is because just now Mr. Chairman asked me with regard to this, and even on the last week we had a workshop in KL University. The same question arose. Bar Council members, Mr. Rajendra Prasad asked me. This is one area that should be addressed by the Supreme Court, or this is one that every one of you must address a letter to the ministry. Do it, my friends. This cannot be done even by seminars or workshops. This can be done only by attempting directly to the Prime Minister and the Law Ministry and the Surface Transport Ministry, asking them to make this 6 months as 2 years on par with workmen compensation. There is one more case to be looked into, is check dishonor case. These are also very important issues. I will not go into total depth of the case, but I will see that this is understood in a light way. I issue a check and obtain a policy. My check gets dishonored. The insurance company immediately intimates and phone call kadandi, all by register post with acknowledgement due. Intimates me and the RTA that your policy issued to you is cancelled because the check issued by you is dishonored once. The accident occurred after the notices are served on me. Owner cannot say, no, my policy subsists because that is with me. No. Supreme Court said, after the cancellation of the policy, the accident occurred. So there is no subsistence. And if the accident occurs before cancellation of the policy, Supreme Court said the policy subsists because that was not cancelled by the time of accident. Friends, I am here before you. నేనేదో నాకు అంతా తెలుసుకొని మీకు ఇవ్వడానికి రాలేదు. మీరేసి ప్రశ్నల వల్ల నేను ఇంకా కొంత తెలుసుకునే ప్రయత్నం చేయడానికి వచ్చాను. కొంచెం టైం లేదు కాబట్టి మీ దగ్గర నుంచి మరింత నేర్చుకునే అవకాశాన్ని లేకుండా బాధగా ఉంది. నాకు ఈ అవకాశం ఇచ్చిన మీ అందరికీ నమస్కారం.
Your presentation is gives you on this particular subject and very informative. Thank you very much. Let us meet in some other place or in some other seminar.
May I now request the dignitaries on the dais to kindly come forward and felicitate the speaker as a token of deep respect and appreciation. I also extend my heartfelt gratitude to Sri Bailapaneni Naresh Garu, advocate at the High Court of Andhra Pradesh, for his enlightening session today. Thank you so much, sir. Once again, we welcome all the dignitaries to the 3-day residential orientation program being organized by the Bar Council of Andhra Pradesh and Damodaram Sanjeevayya National Law University. I request our Honorable Sri Nallari Dwarkanath Reddy Garu, Chairman, Bar Council of Andhra Pradesh and President of today's function, to come over the dais and adorn the chair. I also request our fellow student to present a sampling to Honorable Chairman, sir. I now most humbly request the guest of honor of today's function, Honorable Sri Justice L. Nageshwar Rao Garu, former Judge, Supreme Court of India, to come over the dais and adorn the chair. I request Sri Nagareddy Garu, member of the Bar Council, to present sampling to his lordship. I request the guest of honor of today's function, Honorable Vice Chancellor Damodaram Sanjeevayya National Law University, Professor Dr. D. Prakash Rao Garu, to come over the dais and adorn the chair. I request J. Sudarshana Garu, member of the Bar Council, to present sampling to Professor Surya Prakash Rao Garu. I request the guest of honor of today's function, Honorable Vice Chairman, Bar Council of Andhra Pradesh, Sri Siraparapu Krishna Mohan Garu, to come over the dais and adorn the chair. I request our fellow student to present a sampling to Sri S. Krishna Mohan garu. I request the guest of honor of today's function, Honorable Member of the Bar Council of India, Sri Alere Ramareddy garu, to come over the dais and adorn the chair. I request our fellow student to present a sampling to Ramareddy garu. I request the guest of honor and program coordinator Sri Ganta Ramarao garu, senior advocate and member of the Bar Council, to come over to the dais and adorn the chair. I request our fellow student to present sampling to Sri Ganta Ramarao garu. I request Madhuri garu, member of the Bar Council, to come over the dais and adorn the chair. I request our fellow student member to present a sampling to ma'am.
Thank you, everyone. Now, it's an honor to welcome Justice L. Nageshwar Rao garu, former judge of the Supreme Court of India. Sir, pursued his BCom and BL degrees from Nagarjuna University, Guntur. Enrolled as an advocate with the Bar Council of Andhra Pradesh on 29 July 1982, he began his legal career practicing at the District Court of Guntur from July 1982 to January 1984. He then shifted his practice to the High Court of Andhra Pradesh at Hyderabad, where he continued from January 1985 to December 1994. Sir brings with him decades of distinguished experience at the bar and on the bench. Elevated directly from the bar to the Supreme Court in 2016, Sir has served the nation with exceptional insight and integrity till his retirement in 2022. Sir has also served multiple terms as the Additional Solicitor General of India, and we are privileged to have him speak today on the doctrine of judicial precedents and its binding nature, a subject deeply connected to the consistency and authority of our legal system. Apologies. Sir is going to present on a presentation on an art of advocacy in the ever-changing landscape of legal field. May I now request Sir to kindly take the podium and commence the session. Thank you.
Actually, last year when we had the seminar, the orientation program for the advocates, the same day was addressed by this Nageshwar Rao. But same day you are come, sir, last day, same day. We had a very nice discussion on the various subjects among you. After a year, we are gathering here from Kerala University to Vijayawada, to just jump to Vaishak. Hope so. Next year also we will have some discussions on some other subjects. Thank you, sir.
అందరికీ నమస్కారం. I might be speaking in English as well as Telugu for your convenience. I think that will be better. How many of you practice exclusively in the High Court? Can you please raise your hands? I see only about 10-15 people, so I'll have to address lawyers practicing in the district courts. I think that would be appropriate, because when I'm asked to speak about advocacy in the changing legal landscape, I have been an advocate for a long number of years, till about 2016, till I became a judge for about 6 years. Constitution permits only judges who are retired from the High Court to practice law in the Supreme Court or in the other high courts in the country. There is a bar for us to practice. So we cannot practice anywhere in this country, either before the tribunals or before the courts. This has been troubling me. Recently I was doing an arbitration in Delhi. I saw Justice Nagarjuna Reddy walking in with some other lawyer. I asked him, have you come to conduct an arbitration here? He said, I've come to argue an arbitration as a lawyer. I felt very envious. Nagarjuna and me started practice at the same time in Hyderabad. Nagarjuna has the facility to argue again as a lawyer, which facility I don't have. I am searching for opportunities to appear before international courts, commercial courts, either in Singapore, London or Dubai, because there is no bar for that. I want to break the ceiling. No retired judge of the Indian Supreme Court has done this. Why I am telling you all this is, advocacy is very close to my heart. I never wanted to become a judge. I was almost forced to become a judge because I said no twice and I thought destiny was chasing me. I think life is like that. You want to do something, but the Almighty thinks of something else for you. Even when I was a judge, I used to dream about arguing cases. I once had a dream where I was arguing before Justice Bhanumati, who was still a judge then. And Justice Indu Malhotra was briefing me. And Justice Bhanumati was asking me, how can you appear? You are a judge of this court. Then I told her, the Constitution has been amended and judges are also permitted to argue cases. It is happening in several parts of the world. In Korea, after retirement, a Supreme Court judge next day goes to court and argues cases. There is absolutely no problem for them. It's only in common law countries that judges don't argue in the courts where they have practice. The reason for my telling you is that advocacy is something which is very exciting. A person gets some sort of a strength when he wears a black coat, not for the purpose of fighting with police and then trying to escape traffic police. No. Not for that. But there's some power that is given by a black coat and the bands that you wear. At least I was feeling it. Every day when I was walking to court, I used to get a lot of confidence in myself. Not being an ordinary individual, you're something more than an ordinary individual. There are so many professions. You have engineers, you have doctors. They're also very good professions. But a profession which has so much strength is lawyering in court. If you want to become a good lawyer, you should think about first that you have to get competence to go and then argue matters. How do you do that? That comes with training. Where do you get the training? Training initially is in law colleges or the law universities, which tell you the basics of law, and then thereafter you're out for yourself. The old practice was that everybody was going and joining a senior's office. They are working there for about 4 or 5 years, and they learn the tricks of the trade, lawyering, ethics. All these things are taught by the seniors, and then they upgrade themselves into independent practice. I don't believe that's happening anymore. I think lack of seniors or good seniors, whatever be, I see a number of youngsters starting professions straight away, even without having that formal training before senior advocates. I would still recommend youngsters who are coming out of college to have guidance from a very good senior in whichever place you are practicing. You will learn so many things because which are not taught in colleges. Colleges don't teach you everything about practical lawyering. So you have to have training. In foreign countries, continuing legal education is compulsory, which means that once you start practicing, you don't need to learn law. That's what we practice in India. We think that once we wear a coat, we got to get a Sanadhara license, then we need not learn, we need not read. We can practice for the next 40 years, 50 years without even opening books. That's the general feeling we have here. Continuing legal education is compulsory in advanced countries. In UK, you have 4 inns where barristers get their degrees. They have been operating for the past 500-600 years. Even solicitors also get their training and then get a certificate to practice in UK. All these inns, which are Inner Temple, Middle Temple, Grace Inn, and Lincoln's Inn, they have their own continuing legal education programs. And all the inns together have training for advocates. It's called Inner Courts Compulsory Education. I think if you can check it, you'll get it. ICA, I think, is the academy, Lawyers Academy. People go there by paying money. There's nothing free there. But everybody wants to be trained as an advocate before they start practicing or continuing to practice. I was thinking, what do I speak when I was asked to speak about lawyering in a changing legal landscape? I initially thought that I should tell you about lawyering in the first place. So I just went to the ICA website and I was seeing what is it that they were speaking about advocacy, which we don't know. So I was actually very impressed by seeing a video. Now all of you have mobile phones, internets, you might be very savvy with computers. I would recommend that if you go, you will get videos there as to what lawyering is all about. There's a 1-hour video where there's a discussion of basics of lawyering. It is the same. It's the same law that we practice. We follow the same principles of UK. We follow the common law principles. The basic thing that is spoken is that you should prepare, and prepare. Three times they say prepare. And what he said is that when a brief comes to you, you should read it 3 times. One general reading for understanding the case, and then you read it. While you read it, you think about what the other side's case is about. If you're practicing in a constitutional court, even the judge is the other side. Because the judges keep asking questions. So you keep judge in your mind when you read. And what would be the other side's case? And the third time you read it on behalf of your client. What would be the strength of your case, and then how is it that you can present your case? My own personal experience, if you ask me, as and when I was reading my briefs while practicing in the High Court for 10 years and later in the Supreme Court, I used to have an inset of the judges in my frame when I was reading. I used to keep thinking, what is the judge going to ask me? How intelligent is he to understand everything? What sort of arguments should be advanced before him? There are judges where you need to be slow. There are judges before whom you can be very fast because they have read the papers, they know everything. There are judges who need to be persuaded when you are arguing. There are judges sometimes where you need to stop them from asking too many questions. There are more rambling judges in this country. So having a judge in your mind is a very compulsory thing when you prepare the case, apart from the other aspects. You prepare a case and then go argue before court. As I see from my own personal experience is this. Ethics is a very important part of profession. Integrity of an individual is something which you cannot negotiate. Every person who joins this profession wants to make this a career. A career is not like business. This profession is not business. If you want to make only money and nothing else, I think you shouldn't join the profession in the first place. But mind you, I'll tell you that if you don't think about money, you only think about being a good lawyer. I will not use the word successful lawyer because success nowadays is in terms of the money that you earn, the number of cars that you own, the number of houses that you have. I only say that you want to become a very competent and a good lawyer. Once you succeed in making a name for yourself as a lawyer, money flows. You would not know the amount of money that you're making once you succeed as a lawyer. But if you start working for money, you're only making money and not a name as a lawyer. There are so many people in your profession and outside who will not recognize you as a lawyer, a good lawyer. They say it's all right, he's also making money. So please don't join this profession for money, and if you still think that I want to make more and more money, I would say that you should go and do some other business. The third time when I was offered judgeship, Justice T.S. Thakur asked me, what is it that you have not done? Why is it that you don't want to become a judge? Then he said that if you are thinking in terms of money, even a scrap dealer makes crores and crores of rupees. So he said there's something that you have to give back to the society. I'm using this only for the purpose of saying money is not important at all. It is a consideration. You'll also have to live. And while living, you should live a decent life. You have a family to take care of. You have children who have to be educated. All these taken into consideration, but should not think about the other counsel has 2 cars or one counsel has a bigger car, I don't have one. I think please don't go by this consumerism. This actually leads you away from the path of rectitude. And as I said, ethics is very important. Ethics, when I speak of ethics, I'm not going to give you a class on morals. I'm only going to tell you that every one of us know what is right and what is wrong. It's just a matter of comparison. I might be able to justify myself tomorrow. You said most of you are practicing in the district courts, you might be practicing in the criminal side. You must have met a number of clients who have come to you. Every person has a justification for what he has done, including a grave crime. So there's nobody, very few people who say that I've done it and then there's remorse. That will not happen. Likewise, every human being has a justification for what he does. I might say it's all right, everybody is doing it, the world is like this, so I'll also do it. But let us make the change. All of us, I think, have to decide that we are in some sort of a profession. I'm not going to use the word noble profession. You must have been hearing it from the day you joined the profession. I'm not going to pitch it that high that it has become very noble, but at least this is a profession which is very, very important in imparting the justice in the society. The only institution that people have confidence is the judiciary now. I'm not saying judiciary is doing everything right, but I'm only saying that people still have confidence. And if the confidence in judiciary is to continue, it is on your shoulders. It's only the lawyers who can impose confidence in the public that I'll get justice. If I go to court, I need not go on a different route, or I need not go and then settle it through a panchayat otherwise. So integrity is something, ladies and gentlemen, please remember that you should not sacrifice integrity. When I said integrity, integrity is your character. That is not waving, not going outside the path of rectitude. Don't be corrupt. Don't encourage anybody to say that I'm going to pay some money. Or don't corrupt anybody don't hear anybody, or don't let the clients tell you that you can manage a judge. Or otherwise you can manage the other side lawyer. This is what we keep hearing outside. You go to a society of people where there are no lawyers or judges, you don't have a very good name. Actually, we are, I think, compared to scorpions and snakes. That's the reputation of lawyers. I remember Justice Kodandaramaya, who is Justice Narasimha's father, telling me initially when I started my practice. I met him long number of years back. He said that he went to Varanasi. And then when he went to Varanasi, he was a person, though he shifted to Hyderabad, he was not very familiar with the language of Hindi. So he was finding it very difficult to communicate with people there. And then the only thing that he could communicate to them, that is a vakil. So he was given a lot of respect in Varanasi only because he told them a vakil. Till then nobody was even looking at him. So he was telling me that's the respect that an advocate gets. But are we getting the same respect now? I'm not sure. If you go to the society and they say, don't wear your black coat, just leave it and then say I'm a lawyer. So without any fear, I don't think you get any respect from the people. All this is only because the general opinion of the public being that we are all persons who do not have integrity. That has to change, and the change has to come only from us. Because the interface of the judiciary with the public are lawyers who are practicing in the district courts. People in the high courts might be meeting a few lawyers, but otherwise you are the people who actually exchange your views, interact with clients. Their opinion about the profession comes from you, the way you behave. So ultimately you are the most important persons who will uphold the good name of the judiciary. So much on integrity. I'll now leave the topic of integrity. When you speak of lawyering, I haven't come to the changing legal landscape. When you speak of lawyering generally, you talk about preparation, you talk about cross-examination in courts, you talk about drafting, you talk about hearing. These are things which normally you do. So how to prepare a case? I told you that you might have no shortcut except to do some hard work. When I say hard work, I have seen people working for 14 to 16 hours every day without doing anything else and still not being able to be successful lawyers. See, there should be a break, and that break comes in everybody's lives, and this break also makes ordinary people great people. If Mahatma Gandhi was not thrown out from his railway compartment in Bloemfontein in South Africa, he would have been actually practicing there. He was doing very well as an advocate in South Africa. All of you know that he purchased a first-class ticket and then he was not permitted because he was not a white. And there he thought, why is discrimination? And that's where Mahatma Gandhi started thinking that he has to come back to India. And after he came back to India, everything is history. So Mahatma Gandhi was such a great person who led the freedom movement. Likewise, there was another lawyer, I'm only talking about lawyering community, who was having a good practice. He was really not bothered about what was happening. He was making good money. One day, he saw a leper who was being mistreated by everybody. You see a leper and people will start running away. And nobody was even taking care of the leper. So he saw that, and that incident changed him. And he became Baba Ante. He left the profession. He was only working only for people who were having no privileges at all. So there are certain incidents which will change life. There is one case that might change your life. So when is that case coming? For some people, it comes within 6 months of their joining the practice. They're very lucky. For some people, it might take 3-4 years to come. I'm not talking of one case which leads to a number of other cases rather. But would you be ready when the case comes to you is the main question. Somebody comes to you and then says that I want you to file a case, whether you're ready to draft, whether you're prepared to go and argue. So initial days of the profession, I would say that each one of you should be ready to handle matters that come your way. I had practiced for 10 years in the High Court before going to the Supreme Court. I was doing reasonably well as a lawyer in the High Court. I had sufficient number of cases. But when I went to the Supreme Court, I found that I know nothing about constitutional law. What I knew was only speaking English and then writing a few sentences correctly. Whatever I did for 10 years was really not sufficient. So if I had to compete with competent lawyers in the Supreme Court, I had to prove myself. The initial 1 year of my practice in the Supreme Court was spent mostly in the library and the consultation rooms where I used to sit and read. I started reading from the fundamental chapters, fundamental rights chapter onwards, and I read almost all the books on constitutional law in that 1 year, apart from various other laws because I was getting some cases. Whatever I was thereafter, I had a reasonably successful practice in the Supreme Court. I was lucky in getting breaks, but when I got that break, I was doing well as a lawyer. That is the reason one case led to two cases led to 20 and 200 or whatever. I was so fortunate in appearing in almost all the high courts in this country. Most of the judges before whom I appeared were my junior judges when I became a judge. And most of the judges before whom I have appeared are in the Supreme Court or in the high courts. All this is because I was fortunate in getting cases. That's not sufficient. All this is because I also worked very hard. So when the case came to me, I had to do well. And for doing well, I had to prepare. When I prepare, I'm not a genius. I'm not very intelligent. I keep telling everybody I'm not as intelligent as Justice Rohinton Nariman or some other judges who are brilliant. What I used to do, which I learned from Mr. P.P. Rao, I don't know whether you have heard the name of Mr. P.P. Rao. He was a brilliant lawyer, a senior advocate from Prakasam district in Andhra Pradesh. He didn't practice like me in Hyderabad. He was in Delhi. He was teaching law in the Delhi Law University, and thereafter he became an advocate on record. He was an advocate on record for the state of Andhra Pradesh, became a senior counsel, and he argued several important matters, including constitutional questions of law. Whenever we used to go to brief him initially as junior lawyers, he used to write notes. You go the first time you weren't then brief him, he used to write notes. He used to call his stenographer and dictate. You go the second time, after notice is issued, the matter comes up for hearing, you go and brief him again, he used to write notes again, call the stenographer. So I asked him once, in the normal course, you write notes once, and thereafter when the matter comes, you read the notes and then go and argue. So he said what I just told you. He said that I'm not very intelligent like others. I make it up by reading a brief 5 times, at least to reach the level of the other people. But that definitely makes you more prepared and more confident to argue in courts. That's what I used to do. I used to read briefs more than required. So anybody and everybody who's here, you said you're practicing in district courts, you might be coming from mofussil areas. I'm from a very small village. So for me to have gone all the way to Delhi, become a Supreme Court judge like Justice Ramana, or like Justice Chalmeshwar, or some other judges of coming, Justice Narasimha, he became a judge not on the basis of his being a judge's son. He did all by himself. He was practicing in the Supreme Court because I know Justice Narasimha from the day he started the profession. So everything is self-made. A person has to do everything on his own. Here, there's nobody who is going to do anything for us. Each one of you is operating in silos. See, only a few people might be having somebody trying to promote you, but most of us don't have anybody to even promote us. Each of us has to promote ourselves, and the recognition should come only from merit. So what I would say on this topic of how to be prepared in a matter and breaks coming their way, I am sure that everybody gets a break. I am sure that each of you, if you work hard enough, will be doing reasonably well. You can't compare yourself with somebody else who's doing extremely well. That's only going to give you some sort of a bad feeling. You should be happy with what you are, and then you should try to improve yourself. You should try to improve yourself more as individuals than as successful lawyers. You should be a good human being to be a good lawyer, and thereafter you become a very good lawyer. So after this preparation, you have been having all these cases so many years. You have been after independence, you have been seeing civil law, criminal law. These are the two things mostly which you do in the district courts. Now, when you speak about this changing legal landscape, how is it changing? I've been seeing it changing for the past 30 years, especially during the past 10, 15 years. You had the Commercial Courts Act, which has been promulgated in 2014-15 or whatever. So, this Commercial Courts Act was made after discussion for about 10 years. In 2008, there was a proposal, but ultimately it took shape only in 2016 or 15, I'm not very sure. The idea is that even at the district court level, you have commercial courts which would be definitely different from the civil courts which are already there. All the commercial matters will be decided fast because we want to improve ourselves as a big economy. We're already the fourth largest economy, you must be knowing. So commercial matters are some branch of law which I think people should think about. They're not different from the regular matters that we were doing earlier in civil courts. They're only different because of the commercial angle given to it. Nowadays, you speak about commercial courts and commercial matters being a different branch of law. Arbitration is something which is connected to commercial courts. All of you must have heard about arbitration, but I'll tell you some give you some very interesting information about arbitration, and then how the perspective in India is and how well it is in the world outside. Because after my retirement, I'm doing only arbitrations, and I'm doing international commercial arbitrations. The perspective of advocates in India who are lawyers in arbitration and judges in India is completely different from what it is outside. Arbitration is, if I can use this word, some sort of an activity which a lawyer does after finishing court work. You want to do litigation, your main job is to go to court and argue cases. Whenever you find time, it's all right, I'll work in the evening also, I get some extra income by going and appearing in arbitrations. That's what arbitration lawyers do in India. Insofar as judges are concerned, their problem with arbitration is they do so many other things. Arbitration is only one branch along with so many cases that the judges deal with. You take High Court judges and Supreme Court judges. There's no choice for a High Court judge or a Supreme Court judge to say that I will only do one branch of law. So for a month or two, they will be doing criminal cases. For a month or two, they will be doing civil cases, otherwise arbitrations, taxation. Mostly interested in constitutional courts are interested in upholding constitution, liberties, rights of individuals. So their perspective is only to learn more about jurisprudence relating to constitutional law. And they'll be thinking about administrative law, corporate law, they'll be thinking about so many other things. Arbitration is only a small branch. So they don't have the time to really understand what arbitration is about. Arbitration itself is a wealth of knowledge which you have to learn from. What I've seen after my retirement is that being an arbitrator here in India is different from being an arbitrator outside in international arbitrations. I will tell you about lawyers from India, youngsters who have passed out law from India. They are in hundreds outside this country who have gone. Let me tell you about London. In London, there are a number of lawyers who have gone there and qualified themselves to practice in London, or otherwise they're doing arbitrations. I've spoken to two persons who are extraordinarily intelligent. One person's name is Dipen Sabarwal. He's from Lucknow. He studied in the National Law School at Bangalore. He wanted to start practice in the Supreme Court. He comes from a middle-class family in Lucknow. He told me that he came to Delhi, then he thought that he'll not be able to survive in Delhi because he didn't have the financial wherewithal to take a house and rent a small house and start practice and wait for 10 years, 15 years. You do not know when a person will start getting work. So he thought, okay, let me get out of the country and then do something. He went to White & Case, is one of the largest law firms in the world in New York. They have branches elsewhere. He went and joined there as an intern and became a partner. At the age of 39, he was given a silk in the United Kingdom, that is a senior counsel. The top counsel in India, Hari Salve, he shifted to London about 15 years back, and he almost fought for about 10 years to be given that silk, becoming a King's Counsel. Earlier it was Queen's Counsel. Here in India we call it Senior Advocate. So at the age of 39 he became a King's Counsel. And he is doing extremely well as a senior partner in White & Case in London. I asked him, why did you go away from India? He said, sir, I'll be very frank with you, that I found that surviving in the profession in India is very difficult. Number one. Number two, he said, I don't like to say it in public, but I will repeat what he said. I'm definitely not going to be held for contempt. He said at least 85% of the judges in India are either inefficient or incompetent. See, this is the reflection of a young lawyer for his feelings. Then I was thinking, when he said inefficient, he was not demeaning any judge in India. He thought that the level of intellect in the judiciary is lacking, according to him. There's another person by name Niranjan, who is even younger to him. He was working with Mr. Arvind Datar. I don't know whether you have heard his name. Arvind Datar is a senior advocate who is practicing in the Supreme Court. He's from Chennai. He has old parents. He wanted to take care of his parents. He did not want to shift outside the country. But he was suffering because he is an extraordinary lawyer. He has photographic memory. He was suffering because he was not getting a chance, and whenever he was getting a chance, he found suffocated because he was not able to really succeed in the profession and making the judges understand what he was saying. So Arvind Datar suggested to him, I think you're wasting your talent here, get away. And his parents also said, it's all right, we'll take care of ourselves, you can keep coming and going, you go. He shifted to London. And after completing only 9 years in London, he was made a King's Counsel recently, 3 months back. So even he is of the opinion that he would not have succeeded in this country. And there are hundreds of people who are going. Is this justifiable? According to me, it is not. This is brain drain. See, you study here and then go out and then your intellect is not being used by this country. That's not correct. So you'll have to stay back and then prove yourself. You'll have to withstand the competition and then succeed here. Good luck to them, they've gone out. We have enough number of lawyers here. I'm told there are 50,000 lawyers in Andhra Pradesh. So by their going away, nothing is going to happen to this country. I'm not saying anything against them here, but I'm saying that if you are a person who's competent, stay back here and prove yourself and change the system if you can. That's what we should do. So I will come back to where I started in arbitration. I said that when we are speaking of a legal landscape, what I'm trying to tell you is, in this country, petitions under the Arbitration Act for setting aside the awards are filed in the district courts. All of you must have argued these petitions filed under Section 34, Section 9 for interim orders. So most of you must be aware of the Arbitration Act. Arbitration Act is very paying in the sense you are not dealing with people who do not have money, you're dealing with businessmen, you're dealing with people who are investing money. So if you are to become a good arbitration lawyer, then you might have to get good training in arbitration. There's one aspect which I want to tell you here. There is a serious roadblock in our minds. When we think that we have finished law, we think that we don't need to learn anything. I already mentioned it to you. This is a problem not only with lawyers, this is a problem with judges also. Judges cannot be told that they should be trained. It will be an offense. You go and tell a judge you have to go for training. So we use the word orientation. Let the judges go for orientation. See, High Court judges go to Judicial Academy at Bhopal for their training in various subjects. Each judge goes. Supreme Court judges, they don't go anywhere at all. They don't need training because they become gods. I use myself, we have become gods. That's what we feel. That's not correct. Last month I was in Bhutan training advocates to become arbitrators. I went with an international contingent of people from Singapore and London. We trained lawyers there for 2 days. Half a day, we were asked to go to the Supreme Court and speak to the judges there. And I was asked to take the lead by the other members who were not judges, but who were only arbitrators. I asked them why. They said, judges will only listen to judges, they will not listen to other people. So I went there and then spoke to them. I found them to be so modest at the end of the day. All those judges walked up to me and said, sir, we want more orientation because we didn't know that there's so much outside Bhutan. Bhutan is just developing as an arbitration jurisdiction. They said, please let somebody come and then we will attend a training course. I said, this will definitely not be the sentiment in India. If I asked the Supreme Court judges, you also have to be trained, they would have thrown me out. So there are people, even at an elderly age, who want to learn. There is absolutely no stopping learning. Even we learn all the time. Even at this age, I learn. There's so much to learn. I keep telling myself, I don't know anything. So that's the only thing that keeps everybody going. If you think that you know everything, you'll stop learning. So as I was talking about arbitration, if you think that it's all right, I've seen the Arbitration Act, I know everything, that's not correct. I think you'll have to think about if you want to become a good arbitration advocate for which there's a lot of scope, not only in domestic arbitrations, even at the international level, you should start attending courses. There are online courses now, you need not travel anywhere. So if you can, go to your internet and then see who's offering these online courses. Then you'll start learning. So when you get some work, you will definitely be noticed as somebody who knows more than the others. How is it that a person succeeds in the profession? When you are on the stage where you are performing, how best you can do it is the question. I was just telling you about this is Nagarjuna Reddy, he has come. So I, To repeat what I said, నేను ఏం చెప్పానంటే ఓ 2-3 నెలల క్రితం నేను ఢిల్లీలో చూశాను. నువ్వు ఆర్బిట్రేషన్ కండక్ట్ చేయడానికి వచ్చావని అనుకున్నాను, కానీ నేను అడిగి నువ్వు కేసు ఆర్బిట్రేషన్ ఆర్గ్యూ చేయడానికి వచ్చావంటే నాకు చాలా బాధ వేసిందని చెప్పాను. నువ్వు ఆర్గ్యూ చేస్తున్నావని సంతోషం కంటే నేను చేయలేకపోతున్నాను బాధ. That's what I was telling them. I took the liberty to take your name. As I already told you, we have been friends for such a long time. We started practice together in the High Court. I just took that incident to say that advocacy is something which is very close to my heart. Even today, I feel bad that I'm not able to argue cases and chepta and all. And I was trying to tell them how gifted they are to be advocates, and what is it that they have to learn to become successful advocates. So as I was speaking about arbitration, I would suggest that all of you go to the internet, find out where you can get some information, where you learn advocacy. There is another branch of law which is very important now when you're talking about the changing legal landscape, which is mediation. You must have all heard about mediation. Practicing mediation is very difficult. Everybody thinks that mediation is very easy. ఏముందిలే ఇది పంచాయతీ కదా, వాడిని తీసుకొచ్చి కూర్చోబెట్టి మాట్లాడి 2 మాటలు వాడు ఎవడో ఒప్పుకుంటాడని. There are a lot of science to mediation. Mediation in this country is necessary. Why is it necessary? Because we have more than 5 crore cases. ఇవి ఎప్పుడు పోతాయి? ఆ నీతి ఆయోగ్ చెప్పినట్టుగా 326 సంవత్సరాలు పడుతున్నట్టు ఇది అవకాశం. సో ఈ లోపు మనం ఏమన్నాం, మళ్ళీ దాని తర్వాత ఇంకొక 5 కోట్లు యాడ్ అవుతాయి దీనికి. సో ది ఓన్లీ వే దట్ ది పెండెన్సీ ఈజ్ రెడ్యూస్డ్ ఈజ్ టు ప్రమోట్ మీడియేషన్. అండ్ యూ హవ్ బీన్ డూయింగ్ సో మెనీ థింగ్స్ ఫర్ ద పాస్ట్ 20 years. Mediation promote చేయడానికి recently we got that Mediation Act also, it's promulgated. Most of the provisions are not notified. But mediation as a profession is something which lawyers do not know in this country. Mediation is always a pro bono activity. Judges ఉన్నప్పుడు హైకోర్టులోను సుప్రీంకోర్టులోను ఆ కోర్టులో ఉన్న సీనియర్ అడ్వకేట్ని కెన్ యూ ప్లీజ్ మీడియేట్ అని పంపిస్తారు. High courts and Supreme Court have mediation centers. Mediation centers have trained mediators. According to the MCPC, which is the Mediation Cancellation Project Committee, 40-hour training is necessary for mediators to be on the panel. That's a minimum. And then you have 10 mediations which you should do to be on the panel. A trained mediator would make much of a difference insofar as mediations are concerned. Now, what is happening in the district courts? All of you are aware of what I'm going to tell you. Referral judges are not trained in this country. Referral judges are judges who are dealing with your civil cases. Section 89 CPC says that before starting trial, a civil judge has to explore the possibility of sending a matter either for mediation, arbitration, or judicial settlement, which normally is not done, because referral judges are not trained, number one. Number two, I was speaking to some district judges some time back as to why referrals are not happening from the district courts. They were saying that there are not sufficient number of trained mediators in the districts. So they say even if we send these matters for mediation, they just come back because advocates don't take too much interest. Why are they not taking interest? Number one, the money paid to these mediators is very less. Number two, mediation is not taken up seriously. Number three, those mediators who are trained are not properly trained. There are certain organizations which give a certificate of training for 1 day or 2 days, that is 6 hours, 8 hours training. That is not sufficient. I am told that the Chief Justice of Andhra Pradesh has taken interest in ensuring that all referral judges are trained. Yesterday I was speaking to a district judge from Visakhapatnam. Then he told me, Giridhar, he is now in VAT tribunal, he told me that most of the referral judges have undergone training. And here in this state, what is left is training of advocates as mediators. So who are going to do it? MCPC was doing it. The Chief Justice also took steps in this. Hariharnath Sharma, who is now a High Court judge, when he was in the academy, he took a lot of interest, is what he told me, in training mediators. Let me tell you, mediation as a profession is lucrative. Right now, no, in India. Outside this country, it is. You have mediation bars, and I am told by people who only do mediations, nothing else as lawyers, they make equal amount of money as people in litigation. లిటిగేషన్లో ఎంత డబ్బులు సంపాదిస్తున్నారు అంత సంపాదిస్తున్నారు, ఎందుకంటే పేమెంట్ అలా ఉంటుంది లాయర్స్ మీడియేషన్లో కూడా. మనం ఇక్కడ ఏమనుకుంటామంటే మీడియేషన్ అంటే నా కేసు పోతుంది అనుకుంటాం, ఇది సెటిల్ అయిపోతే నేనేం చేయాలి ఇంకా అనుకుంటాం. దట్స్ హౌ lawyers are seen to be the villains of mediation in this country. Mediation is something which is to increase as a profession. Recently, I think last month, the mediation bar of India was started by the Attorney General. He is now the first president of the Mediation Association, Mediation Bar Association. So the idea is now to ensure that lawyers take mediation as a profession and not an avenue where they lose work. See, even if I am a person who has 3 or 4 matters, and then if people say that these 3 matters can be settled through mediation, I'll think twice. Once these are settled through mediation, what do I do? But if you also take it as a profession, and then being a mediation lawyer also is paying, once matters are settled, there will be more people who want their matters to be settled, and then you will get enough money or sufficient money as you are getting in litigation. Might not be if you are prolonging the litigation, but otherwise in the number of cases that you might handle, you will definitely be making sufficient money as a lawyer in mediation. Mediation lawyering again needs training. It is not done here. Mediators are trained. Mediation lawyers are not trained because we don't have sufficient training institutions in India. So there was a move in the MCPC when I was there, and thereafter Justice Sanjay Kishan Kaul also took it up. Earlier, what was being paid to a lawyer in the mediation committees of the high courts was a pittance, very less, 3,000 rupees or whatever. And then if the mediation fails, they don't give you anything. A successful mediation gets you 5,000. Now they've increased it, I think, about 7,500, 10,000. I was telling the present MCPC committee that you're allowed to increase even further, make it a little more lucrative for people practicing in the district courts to spend their time as mediators. If you want to spend time in mediation, you should also get some money. So you can't keep wasting your time on mediations. So mediation is something which has to be promoted. Mediation is for the future. I'm sure once the Mediation Act is notified, where ఇప్పుడు వరకు ప్రాబ్లం ఏంటంటే if 2 parties settle in mediation, these 2 parties are not sure whether the settlement is enforceable in a court of law. Because of the Mediation Act, it is like a decree. Once it is there's a settlement, you can go and then enforce it a decree. Nobody can go back on that. So there is some sort of an assurance that a mediation settlement also is enforceable. So I would request, or I would recommend all of you to take mediation seriously. You have to go through a 40-hour course. After my retirement, I underwent a 2 40-hour course training in mediation. Not because I wanted to become a mediator or a mediation lawyer. There was somebody who started spreading a word that judges can never become good mediators. They only know how to shout at lawyers in court and decide matters, nothing else. So I just wanted to prove to them that that's not so. See, mediation is not adjudication, all right, but you cannot say that every judge is not a good mediator. They can be mediators also, because if lawyers can be mediators, why can't judges be good mediators? So that's the reason I went through the course. But I would recommend to all of you, please take mediation also very seriously. There will be training that will be available by the MCPC. I think the High Court is taking up, and at the district levels also the training would be there. And once training is imparted, and once you get training, you would become very efficient insofar as mediations are concerned. So I spoke to you about arbitrations and mediations, which are new branches. They have been there a long time, but there is a lot of scope for mediations and arbitrations as I was speaking to you. I also told you about some commercial law if you can take up, that would also be good. But otherwise, lawyering actually hasn't changed much, merely because you have new branches of law. A person, to be a good lawyer, has to have all the characters which I just spoke to you for the past half an hour, 45 minutes I was telling you. One thing that every lawyer should understand is, first, you should not stop reading. Acquiring knowledge. Knowledge is not restricted only to law. Initially you have to learn law. But otherwise, reading is a habit which you should not give up. I will tell you about a few things which I know of, which have helped in a person becoming a good lawyer. I don't claim to be a very good lawyer, a decent lawyer. When I was in college, my father used to ask me to read. He used to say, why are you not reading? Why are you not getting good marks? I was a very average student. The moment I opened the book, I used to feel sleepy. Very, very difficult to read. I think most of you might be facing it now. Or at least earlier you would have faced it. But once you start taking interest in reading, now I cannot stop reading. If I don't have work for more than 2 days, I feel sick. Work is only reading. You get so much pleasure in reading. You should enjoy reading. And then the knowledge that you acquire, even in branch of law, I was just thinking what is interesting in law when you read. As I said, all of you have access to internet. Just look at the Socrates trial, 399 BC. Socrates was put to trial for impiety. Impiety ante nastikata. What was the charge against him? The charge against him was he did not believe in gods which all people in Athens believed. He used to argue a lot. The charge against him was impiety and the spoiling or corrupting the minds of young people in Athens. Those days, there was a jury trial. 500 Athenians were brought. They were asked to find whether Socrates was guilty or not. 500 mandi. Jury trial later, a judge would be there to guide the jury in US or in UK in some trials now. There were no judges. So Socrates, being a teacher and a scholar himself, said that I'm going to argue for myself. So he had to argue before 500 people. And there is a small book written by Plato, who is his disciple, sort of 15-20 pages, called The Apology. It's available on the internet. So Socrates argued, he said that, what are you trying me for? Just for expressing my views, merely because I don't agree with all of you. You can't try me like this. So he argued for about 2 hours, 2.5 hours. And thereafter, 260 people out of 500 people found him guilty. The remaining 240 people, I think it is 270 to 230, they found him not guilty. Then there was another voting as to what should be the sentence. And thereafter, around 300 people said that he should be sentenced to death. So the number increased. And then he was taken to a jail and then given some poison and then he died at the age of 70. This is not interesting. There is something connected to law. So there are so many stories in law which will really make a very interesting reading. I don't know whether you have heard about a case which is a very famous case called the Bhaval Sannyasi case. Has anybody heard about it? I just said yes here one. Has anybody heard about Bhaval Sannyasi? There are books written in England about this Bhaval Sannyasi. Please say. There was a person from a royal family. I think it is in 1905. He was born, and then this was in the United Indias from the Bangladesh area. He was actually taken to Darjeeling for curing some diseases. I don't want to tell you. There's an allegation that he had syphilis. So he was taken to Darjeeling by his wife for treatment. And then he died. And his body was placed on the fire. And by the time they lit fire to the fire, there was a dust storm, heavy rain, and people started moving away from it. They went back to see that the body was not there. They thought it's all right, it is already over, and then they went back. And after about 15 years, there was a sannyasi who appeared on the streets of Dhaka. So he was just sitting in some place for about 2-3 months, and then people saw that this person appears to be like the person from the royal family. And then slowly they all promote him to be taken to the palace or whatever house they are. So he also says, yes, I am the person whom you are talking of. I fell unconscious. His case actually in court was different. And thereafter some Naga sadhus who were going, they took me, and then I was roaming around all over the country, and I came back. And he was not even speaking Bengali, he was only speaking Urdu. People said, what happened to your Bengali? He said, I forgot because I've been roaming around for about 15-20 years. So ultimately there was a suit for declaration that was filed. Because the Board of Revenue also was not accepting that he belongs to the royal family. Otherwise you would get those days, that rents have to be paid by the peasants and landowners to the person who is the zamindar there. So he was getting money. So the Board of Revenue and the government said that we don't recognize him. There was a case filed for declaration. Ultimately, it went to the Privy Council from a 3-judge bench of the Calcutta High Court. And the Privy Council held in his favor, and a few days thereafter he died. The fight was mainly for the property. After he died, there was a forensic examination. I think there would not have been forensic examination like now. Forensic examination, it found that he was the same person. So there are books written about this trial, which was very interesting, which went on from 1933 onwards to the Privy Council. I think there's one book written there, I think a Living Dead Man or whatever, written by... There's something written in England, there are 2 books. So it's quite an interesting case. I think you should read about this. Bhaval Sannyasi, this is much prior. There are so many, hundreds and hundreds of cases like this, which would definitely interest you. Does anybody know which is the last case tried by the jury in India? Nanavati. Right. Nanavati. Great. It is Nanavati. Can you tell me about this case?
The prefect, he is a officer.
Come here. Can you give me a mic? Do I have time?
Briefly, I am aware of the facts. The facts of the case is that he is a naval officer his wife is in illicit relationship with some other person. He has taken his revolver from the what is called service revolver, and he went there and he had shot that person. And later it was referred to the jury, and a trial has been took place. This is the non-average trial properly called.
Yeah, you're right, but what is it that the court held in that case? You're right, what happened? He was convicted, conviction confirmed.
First, he was acquitted, sir, by the jury. Later, he was convicted.
And then conviction confirmed by the Supreme Court.
Conviction was confirmed.
And thereafter he was pardoned. It's all right, I will take it from there. He was pardoned. What was held, which is very important, is that we don't need jury trials, number one. And number two, an interpretation of section 300, like we see about sudden and grave provocation. That's the important point. His defense was sudden and grave provocation. The court said that it's not a case of sudden and grave provocation, but at least we got rid of the jury. Just imagine if we still had the jury and then all these criminal cases are decided by the jury. About people, that's a good idea. So, I just mentioned about 2-3 cases which just came to my mind. So likewise, if you start reading, you will develop a lot of interest. See, lastly, before, one thing is, I always think that it would be better if I can hear from you. If you can ask me any doubts you have or any comments to be made, we can spend about 15 minutes on that. But before I do that, I just wanted to just give one advice. As I was talking about continuing legal education, Madhav Menon, who was, I can call him a jurist also, apart from a scholar, he was the one who started the Bangalore Law School. So he spoke to Mr. Venugopal, the senior counsel, and then they started M.K. Nambiar Center for Continuing Legal Education in Tribunal. Mr. Nambiar was the counsel a number of matters which included Keshwananda Bharti as well. Constitutional questions were argued by him. This was started in 2016. And I am told by lawyers and judges coming from Kerala that this institution is doing very well. I was speaking to Mr. Ramarao that the Bar Council should take the initiative of having a center for continuing legal education in Andhra Pradesh. Apart from this, even the Bar Council of Kerala in March 2025 passed a resolution that they are going to have an institute of its kind. And I assure them of any help from my side, including financial help if necessary, because the government, if it's not coming forward, because I feel that continuing legal education is the only answer for improving the quality of advocacy. Otherwise, whatever lectures we give from this podium, they are not going to suffice. You should undergo the grind. You should understand the forensic skills of a lawyer. It's not that easy. We just learn and experience. Somebody comes and gives a case, we go in and argue. We do not know whether that is right or wrong. There's so much to learn. We learn by experience. But if you're ready there to argue a case when somebody gives you, that can be only by training. I'm sure that the Bar Council would take my advice and start this institution, for which I don't think there are any roadblocks also for that. That is one. And number two, in your bar associations, I'll tell you my experience. I don't know whether you've heard of one judge by name Justice Muralidhar. He was practicing the Supreme Court, later went and became a judge of the Delhi High Court, became a Chief Justice of Chandigarh and Odisha. He is now practicing again. He's doing very well as a lawyer, lucky fellow. When I shifted to Delhi, on Fridays, normally Supreme Court works work completes, and then by afternoon people would want to go home. The judges also are not there, they finish the work and go. Muralidhar was sitting with about 10 people, 2 of them are Supreme Court judges now, Vishwanathan and Narasimha, and a few others. For 2 hours to 3 hours, they used to discuss about the cases that happened in the Supreme Court for the past 4.5 days. Each of them had to give an account of what they argued or what they heard in a court in an interesting subject. So this group discussion continued from then, and even now that is going on. And one Mr. Seshagir Rao, who is a lawyer, he is a lawyer from the erstwhile Andhra Pradesh, now Telangana, practicing there. He is continuing the tradition. So I don't know whether that happens here, but I would advise that in each bar association, such of those lawyers who are interested in learning, if they form a small group by yourself, and at least once in a week, if you can spend those 2-3 hours discussing about the latest development in law, assuming I'm a criminal lawyer. There are so many things to discuss about. In 1 week, there are at least 20 judgments on bails in the Supreme Court. Apart from that, there are so many questions of law that are decided by the Supreme Court. Or if I'm a lawyer doing civil cases, every week you have so much done in the High Courts as well as the Supreme Court. You have access now. Earlier we never had access, only books had to be referred to. So I would recommend and encourage that small groups are formed, and then if you can keep discussing like this and knowing what is the latest development in law, that would be very helpful for you. The other thing that can be done by the bar associations is, you have senior counsel practicing in those bar associations who are doing well. Request them at least once in a week or once in 2 weeks after the court hours, if they can speak to young lawyers, 30, 40 of them, 50 of them, have interaction with the lawyers about what their difficulties are, what is it that is lacking, and what is it that they can learn. This interaction would definitely be useful to the youngsters. These are some small steps which do not need much, but it just needs some initiative to be taken by people in the bar association and the bar councils. So this said, I think I've harassed you for about 1 hour, 15 minutes. If anybody wants to ask me any questions for the next 10 minutes, yeah, please. Can you give me a mic? Do I have 10 minutes?
Sir, actually I came to this group after serving 30 years in central government. Recently I have joined this profession. I found that there are 2 types of styles, affidavits. In one style of affidavit, everything it is written, including the citations, prayer and case laws, everything. Only the covering, just like a covering letter, the petition will be there. As mentioned in the affidavit, we need this prayer. Another style is entire thing will be in the petition, and in the affidavit you will verify those paras I am verifying. Actually, which is better, and why affidavit should contain all these citations? And does it need to contain prayer, actually?
Well, not necessary. Precedents need not be mentioned, but style is the man. Everybody has his own style of writing, as long as it is within the prescribed norms. See, what you are filing in affidavits, when you're talking of affidavits, are you talking of writ petition affidavits?
Yes, writ petitions.
Yeah, see, this also varies
But
from...
also we find in the second style, the entire pleading will be there, only affidavit will verify so and so paras. Whereas in High Court we found that first style, entire thing will be in the affidavit and only forwarding letter like the petition will be there.
The practice in High Courts also is different, because the form of petitions filed under Article 226 differs from the rules that are framed by the High Courts. In the southern part of India, you file affidavits and then a petition along with that. And the relief is shown at the last paragraph of the affidavit as well as the petition. In the normal course, in those affidavits which are filed, you need a chronological list of dates. If you can put it in an order, that will be better. And the grounds that are raised for the purpose of seeking relief. I think that makes it very clear. When you come to the Supreme Court, you file a special leave petition, you already have a judgment with you. You have a list of dates and then you have the grounds, that's all. And the affidavit is only for verification. You need not file an affidavit of the person except for verification. As I said, it all depends on the rules. The idea is to ensure that whatever you are saying is clear. Writing hundreds of pages is only going to confuse the judge, and nobody has the patience to read all this if you want the judge to read it. Yes, yes.
Good morning, sir. Mediation degree is available or final?
Mediation?
Degree.
Mediation settlements.
Mediation settlement becomes a mediation degree. Who process the judicial officer based on settlement? It is available or it is a final?
After it becomes a decree, then you might appeal it, but otherwise they will not interfere. It is final insofar as a settlement is concerned. The Act says it is final. Once parties agree, even you must have seen even in Lok Adalats also, some people try to file appeals. They are not entertained except on grounds of fraud or coercion. Otherwise, they are not.
Sir, I've got two chunks of questions, sir. The first one would be, are we doing enough to integrate technology into the whole judicial infrastructure? I know there's been an investment going on. Do you think that's enough? And do you think that's the right frame of mind and the right outlook also, the way we're integrating technology? And number two is, live telecast of judicial proceedings has also led to a theatrical element on both sides, unfortunately and fortunately. And where do you see that going towards also?
Yes, technology being used in courts, I don't think we can escape from AI taking over our lives. And there is a prediction that AI is going to take over lawyering also. Don't bother, as of now, all of you are not in any danger, especially in this country. For about 2 years before I retired, I was in charge of the AI in the Supreme Court. And we started the program in right earnest. We started having certain programs relating to translation of judgments, and also providing a program which would be useful for the purpose of efficient administration in the court. That we made it very clear that whatever work is done in the administration of the court or justice would not be utilized for making decisions. The machine cannot definitely substitute the man. So decision is taken by the judge because the judge looks into several things in a matter for the purpose of reaching a conclusion which a machine can't. What the machine does is, what we did when we were doing that was, a number of criminal cases were fed, and then thereafter the machine is ready with an answer when you give the facts of the case. But that might not be the result if a human mind is working on it. I think the Supreme Court has done sufficiently enough for the purpose of improving technology in courts. I think all the courts in this country now are connected to the judicial grid, and they are also being monitored. Apart from that, AI is being used in the district courts also. In this vast country, doing this much itself is very good. So much needs to be done. Insofar as live streaming is concerned, I have my own views. I might say that you're right. I can even argue that you're wrong. Justice Clarence Thomas of the US Supreme Court, the longest serving judge on the US Supreme Court, has been there for about 30 years. When live streaming was sought to be introduced in the US Supreme Court, he said that he's opposed to it. In US Supreme Court, all the 9 judges sit together. The Supreme Court works en bloc is what they say. He was afraid that each judge might try to do some sort of a one-upmanship, which means that if I'm sitting on a bench like this, so I would try to show to the world that I'm more intelligent than the others. So I would start playing to the gallery instead of answering the questions or whatever. That's what his apprehension was. I'm not bothered about that insofar as India is concerned. My idea about live streaming is that all important cases pertaining to constitutional law, or even matters where there are certain important issues which the public would be interested in, they can be live streamed, because I know a number of people who have told me that they have been watching the live streaming of the Supreme Court. I'll tell you with my own personal experience as judges, when we hear important cases of constitutional law, etc., the dialogue would be much lesser. The lawyer is permitted to speak more. So there are questions that are put, unlike when we hear SLPs, about 65, 70 cases a day, we speak more than the lawyer. We don't permit the lawyer to speak. And sometimes the atmosphere is really charged. I think the public need not know what happens in court. Lawyers shouting at judges, judges shouting at lawyers. So that's not advisable, and there's no knowledge that is being imparted. So I would say that it should be restricted only to very important matters.
Sir, very good morning, sir. My name is Rishi Kunal. So my question is so there was a legal legend in this country who had once very famously said that if a good lawyer is a person who knows the law, but a great lawyer is a person who knows the judge. Sir, as an eminent personality, as an eminent legal personality yourself, you've been both a lawyer as well as a judge, an honorable judge. So I would want to ask you to elaborate on this as to how is it that we can, know the judge. I mean, in what aspects would it help us in getting a litigation in our favor?
The very lawyer who said that became a great lawyer not because he knew the judge. Jetmalani never knew any judges. So whatever he said was with reference to the present times. Let me tell you, ladies and gentlemen, merely because you have coffee with me or Nagarjuna Reddy when we were judges, we wouldn't have passed orders in your favor. This is a misnomer. And there is something which the lawyers do which should not be done. Being cynical and a sycophant is not going to help. You run behind judges, try to please them outside court, that will not be carried to court by most of the judges. There might be a feeling that some judge would pass an order because of his acquaintance. That's not correct. I was told, I will not take the name, when I started practice, I was told that there was a senior judge who retired by the time I came. So he used to have drinks with some lawyers. Next day morning, the lawyer appears before him and he used to dismiss their cases. So it's not going to help. In the southern part of the country, normally judges do not have drinks with lawyers in parties. In the Supreme Court, Delhi, Bombay, this is common. So, and these parties go on till 11:30, 12 in the night. But things next day morning are completely different. There might be some black sheep, there might be some people, but that's not the norm. Knowing the judge is not going to help. At least I've been advocating since I was an advocate that whatever you do in court is more important. And sometimes judges would find out that lawyers were trying to get to them through all these methods, and that might work as a deterrent.
Thank you.
Sir, last question, sir. I would like to bring you the plight of the young lawyers, sir. Many of my friends are getting demotivated to enter litigation itself because here they are paying very meager amounts, sir. And not only that, how to be motivated? What is the method to be motivated for the younger people? And not only that, recently I had gone to Farida, one of the judgment of the Honorable High Court of Madras, Farida Begum versus state, where it has stipulated some guidelines to the Bar Council of that state, giving certain wages, suppose certain amounts, sorry, we should not say wages, certain amount has been prescribed.
You use the word stipend.
Stipend, prescribed to support the employees. Some initiative should be taken to motivate the employees.
I think there are schemes of the Bar Council where
Nothing like that, sir.
no. I heard that some bar councils pay some money, 1,000, 2,000. No, nothing. Why don't you ask them to pay?
See, in our institute, sir, no one are even interested to go to litigation, sir. They are choosing only corporate. The young minds are completely being deviated, sir.
See,
How to be motivated?
I can understand the problem because long number of years back, even I've seen my colleagues and undergone this. See, it might be difficult to keep yourself motivated, but you should be passionate about it. There is a need. I see some senior advocates also here sitting in the crowd. There is a need for the senior counsel to actually take care of the junior counsel or people who are working in the office. Pay them decently. I think in the constitutional courts they're still paid well. I'm not very sure about district courts. There might be people who might be paying well, but it is for the senior advocates to somehow or other keep you comfortable at least, because we do not know about the future. If you want to continue to in the profession, should survive. Survival would be a problem. I agree with you, but the motivation should come from within the profession, and the motivation should be with you. You have to withstand all these difficulties to make it big. Thank you so much. I congratulate the Bar Council of Andhra Pradesh for having this program on a yearly basis. And the Vice Chancellor of the University, I find that the facilities here are very good. I wish you all the best, and I hope that you have a great future. Thank you.
Thank you, sir. Your presentation is so informative and admirable. Thank you very much. Now, felicitations to the honorable guest.
It is my proud privilege to deliver my vote of thanks to Honorable Mr. L. Nageshwar Rao, former Judge of the Supreme Court of India, for gracing today's session with his presence and wisdom. Your Lordship, we are truly honored to have heard from someone distinguished career spans decades, both as a distinguished advocate and a respected judge. Your lecture today on the art of advocacy in an ever-changing landscape of the legal field was both timely and timeless. On behalf of the Bar Council of Andhra Pradesh and Damodaram Sanjeevayya National Law University and every participant present, I extend our heartfelt gratitude. Thank you.
There will be a tea break for 10 minutes. We will assemble again after 10 minutes. Please finish quickly so that we can go for the next.
5759 cancel
Check. Sure. Sure. Check.
నేను పవన్
Check. Check. Check.
చేసుకొని మ్యాథ్స్ తప్పలేదు. రెడీ చేయించా వాళ్ళందరూ చేశారు. క్లీనింగ్ కూడా చేశారు. క్లీన్ చేయించి ఆ సార్ వాళ్ళ స్కోర్ ఎంత
చాలా చల్లగా
థర్డ్లో ఉన్న వాళ్ళు క్యాష్ పంపించారు. కొంచెం మెంబర్స్ ఉంటుంటారు. ఎందుకు వేసాము మెంబర్స్ 25 మంది మెంబర్స్ కోసం స్టూడెంట్స్ కాబట్టి
వాటర్ పట్ల నేను ఇవ్వను నీకు వాటర్ వద్దా ఇక్కడ కూడా అంట రెండు అదొకటి టెంపరేచర్ పెంచారు ప్రస్తుతానికి అయితే కొంచెం ఆపేసి అసలు ఎంత చలి వస్తుందంటే అసలు కూర్చోలేకపోతున్నాం వాళ్ళు కాదు వాళ్ళ ఫ్యాక్టరీ బాగా చెప్పారు.
నేను వెరిఫై చేసేవాడిని నేను ఎవరైతే గ్యారెంటీ చాలా ఉంది రమ్మంటే వాళ్ళు ఇంట్రెస్ట్ ఉన్నారు అప్పుడు ఏడిగిపోయినా పది మంది చాలా మంది
I request our guest of honor of today's function, Honorable Sri Justice C.V. Nagarjun Reddy Garu, former judge of the Combined Court of Andhra Pradesh, to come over the dais and adorn the chair. I request P. Narasimha Rao Garu, member of the Bar Council, to present a sapling to his lordship. I request the guest of honor of today's function, Honorable Vice Chairman, Bar Council of Andhra Pradesh, Sri Siripura Krishna Mohan Garu, to come over the dais and adorn the chair. I request our fellow student to present a sapling to Sri S. Krishna Mohan Garu. I request the guest of honor of today's function, Honorable Member of the Bar Council of India, Sri Aluri Ramireddy Garu, to come over the dais and adorn the chair. I request our fellow student to present a sapling to Ramireddy Garu. I request the guest of honor and program coordinator, Sri Ganda Rama Rao Garu, senior advocate and member, Bar Council, to come over the dais and adorn the chair. I request our fellow student to present a sapling to Sir. I request B.R. Reddy Garu, member of the Bar Council, to come over the dais and adorn the chair. I request our fellow student to present sapling to Sir. Judge from 2008, delivering over 43,000 judgments, many of which are landmark decisions. Following his retirement in 2018, he took charge as the chairperson of the AP Electricity Regulatory Commission in 2019. We are honored to have him with us today. Now I request Dwarkanand Garu to preside over the talk.
Honorable Justice C.V. Nagarjun Reddy will speak on a presentation of the doctrine of judicial precedents and its binding nature.
Since the ever ebullient, the chairman of the Bar Council of Andhra Pradesh, Mr. Varaknath Reddy, the esteemed members of Bar Council, ladies and gentlemen. The topic I have chosen for this session, that is doctrine of precedents and its enforceability, is purely an academic topic. So I may have to bother you by reading certain extracts. I request all of you to patiently bear with me, because without reading these extracts, the presentation will not be meaningful. The doctrine of precedent is the most pivotal jurisprudential doctrine. This is pivotal because you visualize a situation where on the same problem, in the same set of facts, there will be varied views expressed by the courts in different cases. What will be the position of the society in that case? It will lead to utter chaos and confusion. It will bring in subjectivity in decision making instead of objective adjudication of the cases. Lawyer will not know how to advise his client. Client will not know whether to litigate or not to litigate. Even a judge is in a highly confused Right. The first one is ratio decidendi. This is a Latin phrase, which in English means reason or rational for the decision. When a decision is given, it should be supported by reasons, which are otherwise also called rationale. In Jayanti Verma versus Union of India, AIR 2018 Supreme Court 1079, the Supreme Court held that a judgment not containing proper reasons is not an authority to be followed. In this context, I am reminded of my own personal experience. When I was sharing bench with the then Honorable Chief Justice, the great Justice Singhvi, G.S. Singhvi, a case came up before us. It was a writ appeal filed by the government against the judgment of a learned single judge. It ran into about 116 pages. So previous night, I had to burn my midnight oil. I went through the entire judgment. I was at a loss to know why the learned judge has allowed the writ petition. When the writ appeal came up before the bench, when the government pleader started arguing, I stopped him with the permission of the Honorable Chief Justice and asked the other side counsel, who appeared to be a woman advocate, senior woman advocate. I asked her, so and so, please show us the reasons in the judgment which support the decision, final decision. Back came reply, sorry, my lord, I am not able to find reasons. I said, I am also unable to find, that's why I asked you this question. I've said this not to denigrate the learned judge, to say that a judgment, whether it may run to 100 pages or 200 pages, is of no value if it does not contain reasons. That's why in Jayanti Verma versus Union of India, AR 2018 Supreme Court 1079, the Supreme Court held that a judgment not containing proper reasons is not an authority to be followed. In another judgment, Assistant Commissioner, Commercial Tax Department versus Shukla and Brothers, 2010, 4 Supreme Court cases 785, the Supreme Court described the reasons in a judgment as soul of orders. Soul, Atma, soul of orders. Reasons constitute soul of orders. I recall a hilarious judgment of an English court. That's a judgment rendered in a money recovery suit. The defendant's defense is very, very simple.
unrelated to law. How will you extract butter? How will you extract butter? You extract butter by churning curds, isn't it? The same way as you extract butter by churning curds, you isolate ratio by analyzing the judgment. You have to analyze the judgment. How you analyze? The Supreme Court said this in Fida Hussain versus Moradabad Development Authority, 2011-12 Supreme Court cases 615. I repeat the citation, 2011-12 SCC 615. There are multiple authorities. You need not bother about them. I am just giving certain important decisions, and you can collect various other decisions also, either preceding these judgments or following these judgments. The Supreme Court held in this case that a decision of a court on specific facts, does not operate as a precedent in future cases. If a decision turns on the particular facts of that case, that will not be a precedent for future cases. And this is very important. Only the principles of law, number one, only the principles of law that emanate from a judgment which have aided in reaching a conclusion of the problem are binding principles. See, it has three aspects or three postulates. One is there must be a principle of law that emanates from the judgment, and this principle of law was taken aid of in reaching the decision, and this decision was reached in a particular set of facts of the case. So three important aspects. There must be a statement of law, principle of law that has helped the court in taking a decision, and that decision is on a particular problem or facts. These three are essential features of a ratio, which can only be relied upon as a precedent. So that's why this ratio decidendi is a very, very important sub-doctrine or concomitant doctrine in applying the doctrine of precedent. And I give you an example. Supreme Court said a judgment based on specific facts does not constitute a precedent. I'll give you an example, simple example. Suppose in a promissory note suit for recovery of money based on a promissory note, the plaintiff was not able to prove passing of consideration. So based on that set of facts, the judgment was rendered, which was confirmed by High Court and also Supreme Court. In a subsequent suit where the plaintiff was able to prove passing consideration, the previous judgment will not operate as a precedent because the material facts differ from the previous case to the subsequent case. That's why I said three postulates. The statement of law, which influenced the decision based on specific those set of facts. If you have similar set of facts, then this judgment would operate as a precedent. There is another judgment, Union of India versus Dhanwant Devi, 1996 Supreme Court cases, page 44. It was held, High Court. It is not everything said by a judge while giving judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided, and for this reason it is important to analyze the decision and isolate from it the ratio decidendi. That's why I gave you the example of butter, extracting of butter. Best example, you isolate butter from the butter curds or buttermilk, whatever, Similarly, you isolate the ratio part of it from the entire judgment so that the other part of the remaining part of the judgment will not be considered as precedent. Only that part which constituted ratio would be treated as the binding precedent and the courts. It is further stated that according to a well-settled theory, every decision contains three basic postulates: finding of material facts, statement of principles of law applicable to the legal problems disclosed by the facts, and judgment based on the combined effect of the above, that is, the material facts and principle of law. Taken together, the judgment will be derived. And a decision is only an authority for what it actually decided. This is one of the most important principles while understanding the doctrine of precedent. A decision is only an authority for what it actually decides. What is essence in a decision is its ratio and not every observation found therein. I'll give you an example for this also. Assuming that a particular statutory provision in an act was challenged before a constitutional court, either High Court or Supreme Court. Arguments were advanced in respect of that provision and also with relation to various other provisions. And in the course of deciding the matter, the court will not only deal with that particular provision which is assigned before the court, but also various other provisions which were not subject matter of issue before the court. In a subsequent case where the other provisions which were not assigned in the previous case were subject matter of the dispute, the observations or findings made by the court in the previous case with respect to the other provisions will not be a binding precedent in the subsequent case. In ICICI Bank versus Municipal Corporation of Greater Bombay, 2005-6 Supreme Court cases 404, it was said that a judgment cannot be read as if it is a statute. This is also one other important principle. It should be understood in the context in which it is decided. It is not every observation made or finding rendered on facts of that case that constitutes a ratio and consequently a binding precedent. This is also very, very notable observation because habitually we find lawyers picking out certain stray sentences from the judgment and reading out to the court. That should not be done because that particular observation may not have arisen in respect of an issue which specifically arose before the court. So instead of doing that, what the lawyer has to do is he has to read out the relevant portions of the judgment. In my opinion, while writing a judgment is an art, writing a judgment by a judge is an art. Reading out that judgment on which a lawyer relies upon in the court is also an art. And conclusion. Only with reference to these, you have to explain to the court how the that is revealed from the material facts, and then what is the law governing the field in respect of those facts. and then what was the decision taken by the court in that judgment. So these are the three most important aspects which you need to briefly point out to the court instead of just reading a head note. I tell you, this is a very, very unhealthy habit. Reading a head note is a very unhealthy practice because who is the author of the head note? Who is the author of the head note? Editor is the author of the head note. Judge is not the author of the head note. And most of you must be knowing the modern day thumbnails. Thumbnails, you know. What is thumbnail? Thumbnail.
Video. Live law will be giving a thumbnail.
So, in every video, before you open it, you will have very attractive thumbnail. It will compel you to open the video and watch it. Finally, to your disappointment, there will be nothing in the main content of the video. He says, so-and-so has gone to jail. And so-and-so is definitely going to be arrested. So on and so forth. So many things. It fools you day in and day out. Every day we get fooled. Because we have some fond hope. No, this may be correct. Yesterday it may be, it may not be, today it may be correct. So head note is like a thumbnail. Whatever the editor understands, he may not deliberately do it, but in his own understanding, he tries to interpretation the judgment and prepare the head note. So please never read a head note. As I told you, briefly read the material facts and then the statement of law contained in the judgment and the final decision. Then the court will know whether this judgment is relevant or not relevant. Because I have seen many judges, lawyers, in my days of practice, very senior lawyers, spreading the books, those days all journals, printed journals, spreading all the books as if to scare the judge first. Some of the judges, seeing those books, will adjourn the cases. And some pretext are there. So, a senior lawyer, I still remember, he has brought about maybe 50 books. Of course, I have not counted exactly, maybe around 50 in number from this side, this end of the tables, 3 or 4 tables full length, up to the other end. Then he picks out each judgment, each book, and then he starts reading head note and say, sorry sir, sorry my lord, this is not relevant. So out of 50 books, he must have said 45 books are not relevant. Then I didn't know why he brought all those books. So this is maybe obviously to scare the judge, or maybe because of his own lack of understanding, lack of proper preparation of the case. Whatever perhaps sometimes the seniors may not have much time to concentrate on. Whatever juniors suggest, he will keep all those books and then he will realize on his feet that this is not relevant. He will keep it aside. So don't do that. Reading a judgment in office is a very, very important exercise so that you can save the court's time and you can also win the confidence of the judge. So next, this is what ratio decidendi about. And then next supporting document is arbiter dicta. We may call it arbiter dictum also. Arbiter dictum is singular, arbiter dicta is plural. In Director of Settlements of Andhra Pradesh versus M.R. Apparao, 2002 for SCC 638, the Supreme Court held, it distinguished between ratio decidendi and arbiter dicta. An arbiter dictum, as distinguished from a ratio decidendi, is an observation by the court on a legal question suggested in the case before it, but not arising in such manner as to require a decision. I repeat the same example. In respect of the challenge to the constitutional virus of a particular provision, that was the issue arising. Other provisions did not arise, but still there will be some observations or findings. Those observations will not become a binding precedent because it does not constitute ratio. On the contrary, it will constitute arbiter dictum. The court further held, in the context of explaining what is binding is the ratio of the decision and not any finding of facts. It is the principle found out upon the reading of a judgment as a whole, in the light of the questions before the court, that forms the ratio and not any particular word or sentence. A judgment of the court has to be read in the context of the questions which arose for consideration in the case in which judgment was delivered. In a statute, because in a judgment, every sentence or every word may not have much significance, may not contribute to the value of precedent, unlike a statute. Because in a statute, there is a presumption that no word is surplusage. No word is surplusage because the legislature consciously used every word in a statute. Whereas in a judgment, such a presumption is not there. So, relying upon certain stray sentences or stray expressions is not correct unless those expressions relate to the issue that was arising in the case. Unlike a statute, you need not rely upon such stray sentences or every word. In another case, Shin Etsu Chemical Limited versus Oxy Fiber Limited, 2005-7 Supreme Court cases 234, it is held. It is a well-settled legal position that the ratio decidendi of a case is the principle of law that decides the dispute in the facts of the case. How beautifully it was put. Say in one sentence, they have explained the ratio. The ratio decidendi is the principle of law that decided the case in the facts of the case. If the court thinks that an issue does not arise, then any observations made with regard to such an issue will be purely arbiter dictum. However, arbiter has persuasive value. You have to remember that. You cannot just brush aside arbiter. You can say, my lord, this may not be directly arising in the case, but the opinion requires due weight. So you can persuade the court in another case where the issue actually arises. You can always try to convince the court that though this is arbiter, this has its persuasive value. Then there is another important doctrine or sub-doctrine, if I may say so, which is called sub silentio. It is again a Latin word. I wonder why we still harboring on Latin words. Why our legislators don't, show them in simple English. In English, what is substantial? It means under silence. Under silence. That means where a court's decision implicitly addresses a point of law, without expressly stating it, the decision attracts doctrine of sub silentio. I'll give you an example, very simple example of a specific performance suit. A suit is filed for specific performance of a contract. The plaintiff was not able to prove that he was ready and willing to perform his part of contract. Following the well-known principle of law that the plaintiff who fails to prove the passing, that he is ready and willing to perform the contract, he is not entitled to specific performance, but without specifically stating that position of law in the judgment, the judge dismisses the suit. Then this judgment attracts the doctrine of subsilentio because the court had in mind the principle of law. That is, implicitly he addresses, implicitly, but not expressly stating in the judgment. So this is called subsilentio. And this subsilentio will not operate as a precedent. Because a precedent has to speak out. The statement of law and a particular facts of the case that influences the decision. It is not there. Statement of law is not there. Expressly is not there. It is only by implication. Obviously, you have to infer from the judgment that obviously the judge had in mind this settled principle of law, namely that if the plaintiff is not able to establish that he is ready and willing to perform his contract, he is not entitled to a decree for specific performance. That's what subsilentio is all about. Then another important doctrine is per incurium. A decision made in ignorance of a precedent or in ignorance of a specific statutory provision is hit by the doctrine of per incurium. In a little later, I will explain it in a more effective manner while I give you an example at appropriate time. Very shortly I will do it. So this is all per incurium. There is one other most important doctrine. So far I have covered 4 doctrines. This is the 5th sub-doctrine, which is called stare decisis. Stare decisis. See, in pre-independence era, we had a statutory provision in the Government of India Act 1935, which made the judgments of the Privy Council and Court of Appeal binding on all the courts. So as a result of that provision, the courts used to follow the judgments of Privy Council and Court of Appeal. Post independence, we have also one provision. Can any one of you tell me? Sorry? Huh? We have Article 141 of the Constitution of India. 141, it says that the law declared by the Supreme Court is binding on all courts. There is also one other important provision, Article 144 of the Constitution of India, which says that all judicial and civil authorities have to act in aid of the Supreme Court. So by virtue of these 2 provisions, the judgments of the Supreme Court are binding on all courts. In Valliyamma Champaka Pillai, Valliyamma Champaka Pillai versus Sivathanu Pillai, AR 1979 Supreme Court 1937, AR 1979 Supreme Court 1937, the Supreme Court held that unlike Article 141 of the Constitution, there is no provision in the Constitution that exalts the High Court judgments to the status of binding precedents. The above articles do not confer the power of precedents of the High Court to be binding on the other courts. So we have two difficulties in the absence of any express provision. For example, 141 says the judgments of Supreme Court are binding on all other courts. What about the Supreme Court itself is the question. Suppose there is a judgment of Supreme Court. Can another bench say that it are not bound by this?
Yes, it can overrule. Supreme Court can overrule its own judgment.
Suppose I'll give you this example. A two-judge bench, a three-judge bench is there. It rendered a judgment. Can a subsequent two-judge bench overrule it?
No, more than 5 minutes at least.
Why? Where do you derive this principle from? You are saying no. Is there any provision that says no? You should not do it. Is there any provision? There is no such provision. So similarly, as far as High Court judgments are concerned, is there any provision which says that High Court judgments are binding on the lower courts or binding on the same other benches of the High Court? No. No, merely because it is finding a court of record, there is no express provision which says that these judgments are binding. Sorry? Court of record means what you tell me? What is that? What does it mean? No, you are just stating the obvious. But I am asking you which provision that makes the lower courts being bound. There is no such provision, but because of the doctrine of stare decisis, by applying the doctrine of stare decisis, closes the gap or fills the void created by absence of a specific provision, unlike on Article 141 or Article 144. Stare decisis means, in English, to abide by the things decided. So it is wherever the court say, no, this judgment is, the view is taken by subsequent judgment bench. Contrary to what has already been decided, this principle is implicit in the mind of the court to say that such a view ought not to have been taken. So because of the doctrine of stare decisis, the courts are bound by their own judgments. Even if it is Supreme Court, I'll come to it a little later. So stare decisis is to abide by the things decided. I'll give you one or two citations in this regard. Refresing versus State of Haryana, 1993, 3 Supreme Court cases, 114. It was held that it is the basic principle of the administrative justice that like cases should be decided alike. It is a very sound rule and practice. Otherwise, on same question of law or same set of facts, different persons approaching the court can get different orders. It was further held in the system of justice which is being administered by the courts, one of the basic principles which has to be kept in view is that courts of coordinate jurisdiction should have consistent opinions in respect of an identical set of facts or on the question of law. If courts express different opinions, then instead of achieving harmony, a judicial system, it will lead to anarchy. You remember at the outset I used these two words, harmony and anarchy. Therefore, to achieve harmony and avoid anarchy, doctrine of precedent has to be scrupulously followed, and this could be achieved only by following the doctrine of stare decisis. Because you abide by the things decided already. There is already a judgment. You abide by it. This is what this is a very, very important doctrine, sub-doctrine, state decisis. Two positive doctrines which help the doctrine of precedent being followed is ratio decidendi and state decisis. Per incurium and sub silentio, though native documents, even this arbiter dictum, these three I can say negative. State ratio decidendi and state decisis are positive doctrines. State decisis compels the courts to follow the previous judgments, to follow the precedent. Because there is a lot of confusion, because what are all these expressions? You say precedent, then what is this ratio decidendi? Then what is this state decisis? What is this arbiter dicta? So a proper analysis of these doctrines would show that it's like sun in the epicenter, and these 5 sub-doctrines revolving around the sun in their own orbit. They help following the doctrine of precedent. Some help in eliminating those judgments which do not qualify for being precedents, and some, like ratio decidendi and state decisis, force the court to apply the doctrine of precedent in a positive way. And now coming to the most contentious scenario, where when there are conflicting judgments, which judgment you follow? Which judgment you follow? No, if there are 2 conflicting judgments between 2 coordinate benches, which judgment you follow?
It should be decided by the higher bench. Suppose two judgment has given a judgment, it should be decided by higher judgment.
See,
if there is a conflict of opinion between one high court and another high court, it should be referred to the Supreme Court, and Supreme Court will be deciding on that matter.
See, recently I have experienced this problem as a lawyer, not as a judge. As Mrs. Nageshwara was informing you, that I appeared in an arbitration matter in Delhi, where a question arose whether my client was entitled to loss of profit, because it was a case of contract. A contract which was scheduled to be completed in two years' time had to be prolonged for 7 years. So there is overstay of 5 years. One of the claims made by my client was claim for loss of profit. In support of the claim, I have relied upon one judgment reported in A.T. Brijpal Singh versus Union of India, 1984, 4 Supreme Court cases 59. There, in para 9, the Supreme Court laid down as a ratio that whenever the contract got prolonged on account of the defaults on the part of the other side, that is the employer, the contractor is entitled to reasonable compensation by way of loss of profit. This is the ratio laid down in A.T. Brijpal Singh versus Union of India. The moment I cited this statement, the presiding arbitrator, not the other side, presiding arbitrator confronted me with 2 decisions, which are later decisions, and asked me, why not I follow the later decisions? These 2 judgments are Bartley by Environmental Engineers Limited versus Hindustan Petroleum Corporation Limited, 2024 to SEC 375, and Unibros versus All India Radio, 2023 Supreme Court cases online 1366. What these judgments laid down was that to be entitled to loss of profit, you should not only show that because of the defaults on the part of the employer that you could not complete the work within the stipulated time, but you should also additionally show that during that period of overstay, you actually lost the opportunity. That means some tenders were issued, you were not able to participate in the tenders because of this work, is what the two judgments held. Then I argued that A.T. Brijpal Singh was of 3 judges judgment, whereas this Bartley Boy and Unibros are of 2 judges bench judgment, and only one judgment has noted the judgment in A.T. Brijpal as it was relied upon by the council, but the court failed to deal with that. And in another case, the court has not even noted the existence of A.T. Brijpal. Then I advanced 2 propositions. One is the later judgments which ignored the judgment already in place, A.T. Brijpal, should be treated as per incurium, because it was those 2 judgments were rendered by not noticing the already existing precedent. That is one aspect. Second is the 2-judge benches ought not to have taken different view in the face of a judgment of 3-judge bench in existence. Even if the court, the benches wanted, they have a different view, then the proper thing should have been done by them was to get that point referred to a larger bench. So long as a judgment of a bench is already in existence, you cannot take a different view. No doubt you can take a different view, but you should not decide the case on such a view unless you refer it to a larger bench. Larger bench will decide whether the previous bench, the view taken by the previous bench is correct or not. Of course, I am awaiting the award, not whether the tribunal accepts it or not accept. This is the correct position of law. How the bench, the tribunal appreciates it is a different matter altogether. And in support of my judgments, my submissions, I relied upon 3 judgments. Central Board of Dawoodi Bora Community and another versus State of Maharashtra, 2005, 2 Supreme Court cases 673. Trimurti Fragrances versus Government of NCT Delhi, 2022 Supreme Court cases online, SC Supreme Court 1247. Pradeep Chandra Parija versus Pramod Chandra Patnaik, 2002 1 Supreme Court cases 1. So these judgments have conclusively laid down that judicial discipline warrants that when a judgment is already in existence, a contra view should not be taken, and if the later bench gets a doubt about the proposition of law laid down in the previous judgment, it has no option but to refer it to a larger bench. There again, there is some difference of opinion whether they can straight away refer to a larger bench or they should refer it first to the Chief Justice of India and then the Chief Justice of India in turn should constitute a bench. We are not concerned with that. That's an internal procedure. So, as a matter of judicial discipline, to adhere to the binding precedent, doctrine of binding precedent, a court shall not ignore a view already taken by the previous judgment and render a different view, a judgment on taking a different view, which will lead to conflicting judgments. As I told you at the outset, if there is a conflict in existence, then it will create judicial chaos. So I'll just conclude the topic by quickly summarizing the entire aspect. every judgment is not a precedent. Every judgment is not a precedent. Even if it is a precedent, entire judgment is not a precedent. Even every judgment which contains a statement of law is also not a precedent. It is only a judgment which contains a statement of law applicable to a particular set of facts, and which statement of law found basis for the decision is a precedent for similar cases arising in future. Then a judgment is not only an authority for what it actually decided. What is essence in a decision is its ratio and not every observation. An arbitral dictum, as distinguished from a ratio, is not binding on the courts. It has, however, considerable weight and persuasive value. A judgment passing the doctrine of subsidencio is not a precedent, since it does not contain express statement of law. A judgment hit by doctrine of per incurium is not a binding precedent. A judgment of Supreme Court is binding on all courts. A judgment of Supreme Court is binding on even coordinate benches of lesser strength. Coordinate bench or benches of lesser strength. In the event of difference of opinion, it has to be referred to a larger bench. This is by virtue of the doctrine of stare decisis. If anyone has any doubts, all right. Thank you very much.
The presentation by the Honorable Judge C.V. Nagarjuna Reddy Garu is very thoughtful, admirable, and informative. I hope so. Everybody has noted down this. Follow it in your day-to-day life. Now, felicitation to the Honorable guest.
May I now request all the dignitaries on the dais to kindly come forward and felicitate Honorable Justice Nagarjuna Reddy Garu with a moment as a token of our appreciation and respect. I request all the participants to kindly stay back. It's my honor to extend a heartfelt vote of thanks to Honorable Justice C.V. Nagarjuna Reddy Garu for delivering an insightful and thought-provoking address on doctrine of judicial precedents and its binding nature. Sir, your deep understanding of the subject, drawn from decades of rich experience on the bench and at the bar, has shed light on the foundational principles that sustain the consistency, authority, and discipline within our legal system. Your presence today has greatly enriched this event, and we are truly grateful for the time and wisdom that you have shared.
Now we will meet here by 3 p.m. for the other session. Have your lunch, come exactly by 3 p.m. It's 2 counters now. Okay?
Dear participants, to repeat, please be back at 3 p.m. for our next session. Also, there is a lost and found announcement. We found an identity card on the name Kolla Jayashri Garu, whose accommodation is in the hostel. If you are here, kindly please take your identity card.
ఏరియా ప్రాక్టీస్ ఎక్కడన్నా సుప్రీంకోర్టు అసలు ఫామ్ దేంట్లో కోర్టు మీటింగ్ మా ఆంధ్ర క్రికెట్ అసోసియేషన్ జవహర్ సరస్వతి బాగా సీఎం మ్యాటర్స్ మేము చూస్తాం హైకోర్టు లేదు మా డాడీ కోర్టు హైకోర్టు రీసెంట్ గా
2025.
మా స్టూడెంట్స్ రావాలి. అయిపోయిన వాటర్ బాటిల్స్ కూడా తీసేయండి అమ్మా. ఫోటో తీయద్దు.
నేను కూడా మీకు తీసుకుంటున్నాను ఇది ఒకటి ఇంపార్టెంట్ సింగిల్ తీసుకుంటే బాగుంటుంది నా మొబైల్తో రాదు
సరే అయిపోయిన వాటర్ బాటిల్ తీసారా?
తీసుకోలేదు చాలా ఎక్కువ అంత కాకుండా ఒప్పుకుంటా ఫస్ట్ నేను పాస్ చేయడం నీకు వచ్చేది అనుకుంటా ప్రాబ్లం లేదు ఎలా వస్తుంది ఒకవేళ ముందు కాపీ చేసుకుంటాను నేను ఎలా నేను ఇంటికి వెళ్ళినా మీకు పంపిస్తాను మెమరీ కార్డ్ అతని దగ్గర లేదని మెమరీ కార్డ్ నేను పట్టుకెళ్తే ప్రాబ్లం లేదు ఇప్పుడైతే ఇచ్చేస్తున్నాను మెమరీ కార్డ్ మీకు ఇచ్చేస్తారా
పంపిస్తా అన్నారు. కొంచెం పర్లేదు అంటే ఫోన్ పే వచ్చేస్తాను. వాళ్ళు వస్తే
పోడియం మీద కూడా వాటర్ బాటిల్ తీసేది.
అందరు పంపిస్తే 10 నిమిషాలు అయిపోతాయి. అది వెళ్ళిపోవచ్చు మనం బయటికి.
అంటే ప్రైవేట్ లిమిటెడ్ అని వచ్చింది కదా, ఇది లీగల్ లేదు కదా. ఇన్ కేస్ నెక్స్ట్ మంత్ 5 months వచ్చింది అయితే వర్డ్లోనే పంపించింది. తర్వాత మీకు ప్రాబ్లం అయిందనుకుంటుంది. కార్పొరేట్ ప్రైవేట్ లిమిటెడ్ చేస్తాము, అందులో చేంజ్ చేయలేదండి. మీరేం చేయద్దా, కార్పొరేట్ ఏం మార్చట్లేదు కదా, డాక్యుమెంట్స్ సబ్జెక్ట్ అయితే ప్రాబ్లం ఏంటండి. అయితే ఇంట్రా ఇది ఉందండి. అంటే మీకు దీనికి ఏమైనా సపోర్టింగ్ డాక్యుమెంట్ కావాలంటే ప్రైవేట్ లిమిటెడ్ లేదు అంటే ప్రైవేట్ లిమిటెడ్ ఆ లెటర్ మీద తీసేయండి. మళ్ళీ తెచ్చుకుంటాను. సరే, నేను అది వచ్చినా ఉంటుంది, దానికోసం కాదు.
ముందుకు రండి. రామో ఏంది లంచ్కి వెళ్దామా? బాక్స్ తెచ్చుకున్నారా? ఫుల్ క్రౌడ్ ఉందా?
Just letter it
అంటే ఇప్పుడు లేవు. ఏటి అందరూ మామ వచ్చారు, జనాన్ని పంపించావు కానీ ఎలాంటి మా దేంతో క్లీన్ చేస్తారు అది తీయండి. ఈ షాప్ అనేది ఉంది కానీ తీయండి, అక్కడ చిన్నది వదిలేండి. పోలీసు చూసుకోమా, నువ్వు చూసుకోండి. ఇద్దరు ఒక చీపురు పట్టుకోవడం, పైన చూడండి. అయిపోయినా నేను 10 నిమిషాలు మాట అయిపోతుంది సార్ మీ పని వాళ్ళు తెలిపోతుంది 10 నిమిషాలే ఖాళీ
మెసేజ్ పెట్టారు కదా నేను వస్తాను కానీ టైం
అక్కడ మనలో కూర్చుంటారు కదా వాళ్ళు భయపడతారు
నేను ఏదో టైంలో వచ్చాను
బ్లాక్ కవర్ లో ఒక ప్యాకెట్ ఇవ్వండి కదా 2 రోజులు అయినప్పుడు ఎత్తు ఇచ్చిందమ్మా అదంటే వరకు అలా చెప్పారు సాయంత్రం ఎలా చెప్తారో వాళ్ళు చెప్పండి ఇచ్చారమ్మా సాయంత్రం మళ్ళీ చెప్తారంటున్నారు సాయంత్రం మళ్ళీ చెప్తారు ఇక్కడ అనేది అక్కడ అనేది కదా చెప్తారు దాని వైపు ఫాలో అయిపోవచ్చు
తీసుకున్నాక చెప్పండి
ఎంట్రన్స్ లో రిటర్న్ మాకు మనం ఏం చేస్తున్నారు అన్ని చూస్తున్నారు
అది ప్రింట్ అవుట్ తీయండి సైన్ ఎక్కడ పెట్టాలో అంటే మీరు అదే పెట్టమన్నారు ఏదైనా పర్లేదు సార్ రెండిట్లోనే. సార్ మీది లక్ష్మీ నెలగా ఎక్కడ పెట్టమన్నారు? ఓకే ఓకే
రిపోర్ట్ ఏం ఇవ్వలేదమ్మా? రిపోర్ట్ ఏం ఇవ్వలేదా?
లేకపోతే రౌండ్ సీల్ ఉన్నారు. రౌండ్ సీల్ చేసింది పర్లేదు ఏదైనా పంపించండి. అది పంపించండి అయితే ఇంకా మీరు అయిపోయాక ఒకసారి నాకు పెట్టండి. అది ఫార్మాట్ పెడతాను, అది ఒకసారి నాకు చేయించి రెడీ ఉంటున్నాను. పార్టీతో సార్ అది జస్ట్ మామూలుగా ఫార్మాట్ పెడతాను, దానిలో టైప్ చేస్తాను. అదే పెట్టాను చూడండి, పెన్ నేమ్ కూడా విశ్వ. నేమ్ ఫిల్ చేసి వెళ్ళండి. వద్దు వద్దు, మొత్తం ఆధార్ కార్డు కూడా పెట్టాను. ఆధార్ కార్డు, పాన్ కార్డు కూడా. తర్వాత ఇస్తాను. వినయ్ కుమార్ పేరు, అది విశ్వాస్ పెట్టాలి. మామూలుగా రాయాలి, ఇక్కడ పెన్ నేమ్ ఉంటుంది కదా, విశ్వ. సేమ్ అఫిడవిట్ సేమ్ అది. ఇక్కడ వెరిఫైడ్ అది రెడీ చేసి నాకు పెట్టేస్తే చెప్తే నేను పంపిస్తాను సార్. సరే.
जनरल क्वेश्चन क्रिमिनल प्लीडिंग्स की सिविल प्लीडिंग्स की सिविल प्लीडिंग्स में जनरल whatever you have you produce in the court initial ఇది మీ క్లెయిమ్లో వీడియో చూస్తుంది క్రిమినల్ ప్లీడింగ్ కొన్ని దాచి మీకు అవసరమైన కూడా యాడ్ చేసుకోవాలి. సివిల్ ప్లీడింగ్స్ మన తర్వాత ఎప్పుడైనా సరే మీకు ఏంటంటే కొన్ని ప్రొడ్యూస్ చేసి తర్వాత అమెండ్మెంట్ పెట్టుకుని మళ్ళీ ప్రొడ్యూస్ చేయొచ్చు కదా. అంటే అది డబ్బు దీని మీద అది మనం ప్లీడింగ్స్ దేని నుంచి వచ్చింది ఎప్పుడు జనరల్గా హలో
హలో దానికి టచ్ చేయండి.
ఎవరైనా సరే నాడికి దుమ్ము లేదు ఇంతకుముందే కలిగి మాట్లాడలేదు వచ్చేది చెప్పాను. ఓపెన్ చేయండి ఆ పై చేతితో ఓపెన్ చేయాలనుకుంటా. మాన్యువలే పైన మాన్యువల్ పై కవరు చేతితో ఓపెన్ చేయాలి. అది కాదు ఆన్ చేశారు. ఆ పైన నొక్కాలి గురు That's it. Yeah. Mode control. వస్తుంది ఈ కంప్రెస్ రాను వాళ్ళు కదా 3 minutes తీసుకుంటాం కృష్ణపల్లి షాప్ సూపర్ మీ ఆఫీస్ సైన్స్ స్పేస్ ఎంత అడగండి తెచ్చుకుంటాడు సపోజ్ పెట్టి తీసుకోవడం 7వ రూపంలో ఉంటుంది గ్లాస్ వేసి గ్లాస్ ఒకటి వేసి మీకు మామూలు మెయిన్ డోర్ ఉంటుంది దాని కాకుండా చిన్న గ్లాస్ ఒకటి statement with but counterclaim has on the property. So how you check? Save the rest.
All the participants are requested to sit in your respective seats as the session is about to begin. We request all the participants outside the seminar hall to kindly come inside the seminar hall and take your seats as the session is about to begin. Thank you.
వాటర్ బాటిల్ పంపించాను
పంపించారు
లేదు నా
వాళ్ళు బుక్ చేసినప్పుడు కాదు
బిల్లింగ్ పర్మిషన్ లేకుండా కట్టించారు. అది ఒక్కొక్క పేపర్లో ఒక్కొక్క రాస్తారు. 14 గజల్లో ఒకరంట 6 చెట్లను ఒకరంట పర్మిషన్ లేదు.
We request all the participants to kindly take your seats as the session is about to begin. We request all the participants outside the seminar hall to kindly assemble inside and take your seats as the session is about to begin. Thank you. We request all the participants to kindly take your seats as the judges are arriving. Thank you for your cooperation.
Where the judge is putting.
We request all the participants to kindly take your seats as the session is about to begin. We also request all the participants to keep your phones on silent or on mute so that we'll have an uninterrupted session. Thank you.
అది ఇంట్లో కన్వర్ట్ చేయడానికి ట్రై చేసినది ఎక్కువ ఎంబీ ఉంది కాబట్టి సెండ్ కావట్లేదు. మేబీ ఇంట్లో అవుట్లెట్స్ ఉన్నాయి కదా అతను మోస్ట్లీ ఇక్కడ వరకు ఎవరైనా మూడుకి రీడింగ్స్ చేయాలి జనరల్ ఆన్ బిహాఫ్ అతను కొరియా ఆర్బిట్రేషన్ mediation అది నెక్స్ట్ కొరియాది కూడా
I request everyone to kindly settle down in their places so that we could start with the sessions shortly. Thank you.
I welcome the distinguished dignitaries to the 3-day residential orientation program being organized by the Bar Council of Andhra Pradesh and Damodaram Sanjeevayya National Law University. I request the Honorable Shri Nallari Dwarkanath Reddy Garu, Chairman Bar Council of Andhra Pradesh and President of today's function, to come over the dais and adorn the chair. I request our student to present a sapling to sir. Now, I request our guest of honor of today's function, Honorable Sri Justice U. Durga Prasad Rao Garu, Judge of the High Court, to come over the dais and adorn the chair. I request P. Ravi Kavera Garu, Member of the Bar Council, to present a sapling to his Lordship. I request the guest of honor and program coordinator Sri Ganta Ramarao Garu, Senior Advocate and Member, Bar Council, to come over the dais and adorn the chair. I request our fellow student to present a sapling to sir. I request the guest of honor, Honorable Justice Sri U. Satya Rao Garu, former District and Sessions Judge, to come over the dais and adorn the chair. I request our fellow student to present a sapling to sir. I request the guest of honor B.V. Krishna Reddy Garu, member of the Bar Council, to come over the dais and adorn the chair. I request our fellow student to present sapling to sir. I request the guest of honor Nagareddy Garu, member of the Bar Council, to come over the dais and adorn the chair. I also request our fellow student to preside over. To present the sapling to sir. I request the guest of honor B.R. Reddy Garu, member of the Bar Council, to come over the dais and adorn the chair. I request our fellow student to present a sapling to sir.
The former judge of the Honorable High Court of Andhra Pradesh used to suffer from the Raw alone. Not only as a lawyer or an advocate, but also as a judge. He was a member of judgments on different subjects, which helps even a common people. Now he is before you, and he will present salient features of partition.
Good afternoon. The chairman of the Bar Council, Sri Dwarkanath Reddy Garu, and other members and the distinguished advocates from the nook and corners of the state of AP, and to my knowledge, the faculty and some of the students of the distinguished university. At the outset, the post-lunch session is a curse, isn't it? More so if it is coupled with a sumptuous lunch and taxed with a jarring and a prolonged subject like partitions, a vintage subject. But Dwarkanath Reddy Garu punished me, and you also. We have to bear with him. We'll try to live up to the expectation. Because the subject which is assigned to me, the partition suit nuances, and also the next subject, the testamentary and interstate succession, which is assigned to my brother Sri Satya Rao Garu, have some similarities. We thought it fit to gain some time and also to sustain the tempo. Wanted to avoid the repetitions, and both of us together will take the subject one after another. Please bear with us. First of all, so far as me is concerned, the salient features of the partition suit. This subject is concerned because, as I told, it is a long subject. You might have felt it while doing trial work as a trial advocates partition suits. Because of the nature of the subject, we have to deal with the different allied subjects like Transfer of Property Act, Specific Relief Act, Contract Act, sometimes while doing the partition suits. And also the personal law, because we are now concerned with Mitakshara co-personal property and partition suits relating to Hindus. You have to incidentally deal with the personal laws. And the nature of the suit is such that the preliminary decree would be passed, then final decree petition will be filed, and that will also be inquired into by the trial court, and ultimately final decree will be passed, and thereafter the execution will be taken in accordance with the drafted final decree. So the subject theoretically as well as practically a lengthy one, isn't it? So where to start the partition suits, and that too in a limited time? Let us divide the subject into three aspects which I thought it fit. The persons who are entitled to seek for partition, this is the first aspect of our discussion or interaction. The persons who are entitled to seek for partition, again, this has to be divided, subdivided. Pre-1956 era and post-1956 era, that is, before the advent of Hindu Succession Act 1956, and the persons who are entitled to seek for partition after the advent of 1956 enactment. This classification, most of you know, is necessary because 1956 enactment, Hindu Succession Act 1956, which was introduced on 17th June 1956, has brought a radical change in the aspect of eligibility of the persons who seek for partition. Therefore, if we deal with a topic as to who are entitled to seek for partition, we have to vertically classify them into two groups. One group who are entitled to seek for partition pre-1956 era, who are entitled to, or who are more people who are entitled to seek for partition after 1956. This is the first class, the first aspect. The second one is some third parties will also come as interlopers in the aspect of partition. You may simply say the third party purchasers, is not it? What are the rights and liabilities? How they are affected by the general partition among the co-partners and co-sharers. That is also an aspect we have to look into. And third one is, of course, procedural one relates to the passing of the preliminary decree, then conducting inquiry with regard to the final decree, and passing of the final decree and execution. This is procedural one. What are the changes that have been brought by virtue of the different judgments, particularly that of the Supreme Court? So this is the third segment or the third aspect we have to deal in the context of the partition suits. So far as the testamentary succession is concerned and other allied aspects are concerned, I hope my brother Sacharavagar will take up, and if anything I forgot or I omitted to take, he can carry it out. This is how we want to distribute between us with regard to the basic subject, that is partition suits. Please bear with us. The first one is with regard to the first aspect of the partition suits, as I told you, who are entitled to seek for partition prior to 1956, is not it? The first division of the subject. Before discussing this aspect, we have to also know how the aspect of the partition came into force. Primarily, the Hindu family or Hindu society with which we are now concerned was a joint family. We lived in gregariously, we lived in flocks. The society lived in groups or in joint families. Why? Because the economic conditions, the avocations they undertaken, permitted them to live in joint families rather than individually. Ours is an agricultural oriented country. Economically, even now also, we depend on agriculture, horticulture, animal husbandry, or the other avocations like cobblers or the goldsmiths or blacksmiths, fishermen. All these avocations need a group or collective efforts. Perhaps that was the reason why the people in India throughout the length and breadth of the country used to live in joint families and pursuing their avocations. And whatever income they earned individually was thrown into the common stock called as common hodgepodge, you may call it technically. And the entire amount of that family was spent for the common requirements of the entire joint family. This was the system prevailing in. One elder of the family used to look after or administer that family, looking into the needs of the family, and again, who is technically called as the karta of the joint family, is not it? This was the system prevailing in. Then why the partition, the concept of partition came into? If you carefully look into the political and economic history of the country, again, for the first time in our country, the industrialization was introduced. In 1780 or 60, it was introduced in England. Because we were under the British yoke, it was introduced in our country around 1840 or so. Cotton mills were developed in Maharashtra, Gujarat, etc. And thereafter other industries also came. Industrial output increased, townships increased, and hitherto what items were produced by the manual labor, by the rural artisans, all those implements were produced, all those goods were produced by the industries. And therefore, the village, particularly the rural economies, suffered a lot because they lost their regular works. Ultimately, they had to migrate to the towns in fetch of their jobs, which necessitated a mass exodus into the towns, leaving the villages. This was the situation around 90s and early part of 2000. And this also had a drastic effect, adverse effect on not only losing the jobs, but also slowly but steadily and constantly withering of the joint families. Joint family had to suffer a setback because most of the family members, all the males, young persons used to migrate to the towns, and therefore slowly the joint family system withered and division became order of the day in every second family which were living in the rural areas. That is how the partition system has come, the historians and commentators would say. When the partition was practiced, at that time there was no a statute governing the partition, how the partition has to take, what are the principles to be followed. We didn't have any statute, isn't it? Obviously, the people used to rely upon the customs, usages, other practices, and most importantly, the principles and guidances given in the spiritual texts by the hermits, like Narada, Parashara, Agnivalka, Jimutvahana, who were the religious hermits, not only giving the texts on the dharma, but also artha, kama, moksha, all these aspects, and family aspects governing the marriage, adoption, and a division of the properties most importantly. They laid down certain principles. Those principles in the form of customs being followed by the people. This was the early stage. If you read the commentaries, you will understand it. The most important aspects or the most important or prominent schools of thought with regard to the partition is concerned, we have had two important schools, isn't it? One is very good, Mithakshara School of Law. Please take it. It is not a lecture-oriented session. It is a mutual confabulation. You can intervene and you can give your own inputs wherever we fault, or rather I falter. We readily accept and learn it. As our friend stated, two prominent schools were prevailing, Mithakshara and Dayabhaga, in all other aspects, but most importantly on the partition of the properties. What is the Mithakshara School of Law? What it prominently, or what are the characteristic features of the Mithakshara School with regard to the partition? And most importantly, which areas it was prevailing? Very good. Except the states of Bengal or provinces at that time, Bengal and Assam, the other areas, or we can call it the rest of the country mostly, the Mithakshara School of Law was prevailing. It preached or it proponed some important aspects relating to the partition. The first and foremost is co-personary, is not it? Yes. The co-personary is nothing but a family, or lightly you can take it a joint family, which is a larger concept including all the blood relations, both women and men, from out of which a smaller circle can be drawn in the form of co-personal, means only those male persons who are downwards from the common propositors or common ancestor up to fourth generation. Suppose if a person is there A, for your easy comprehension, A son B, B son C, C son D, up to fourth generation of the males used to constitute under the co-personary, and they were called as co-partners. And what is the right that they have? They have a right in the co-partnering property which they have inherited from their ancestors, or which by virtue of their exertions they earned as individual property, thrown into the common hotspot or blended into the common hotspot. So the co-partnering consisting of the male members predominantly up to the fourth generation from the common propositors, and they have by virtue of their birth in the family have a right in the co-partnering property. This is what one of the main features. The second one is, obviously when the male members constitute co-partnering, it needless to say that women were not given any right. They will be only joint family members but not co-partners. The third characteristic feature is they used to enjoy jointly till a partition takes place, even the male members. Till a partition takes place, no male member, no co-partner can proclaim that I have a definite share in the property, is not it? It is a common enjoyment at that time till the partition takes place. This is one of the aspects. But they can demand partition. And when partition takes place, their shares will be defined depending upon the number of the male members available as co-partners. Another important feature is with the births and deaths of in the family, mostly males, the shares used to fluctuate. Is not it? One more male member, the share of another person will be down. With the death, it will increase like that. Of all, another important feature is the existence of survivorship. Right of survivorship was another important feature. Means, if a male co-partner died intestate, leaving an interest in the co-partnery, his right in that undivided share will devolve upon other living co-partners, usually males, but not on what we now call as class 1 heirs, comprising the women also. That was the situation prior to 1956. If you see this system, we can easily understand that women as a wife or a daughter or a sister, whatever name you may assign, she was not given anything. Then what the women folk as a members of the joint family used to get? They had the right of marriage. They had, if any widows are there in the joint family, they had the right of maintenance. And of course, during the course of marriage, some families, as a tradition, used to give some property, what we colloquially call as Pasupu Kunkuma, isn't it? Pasupu Kunkuma gift used to be given. You might have seen as an advocate, you might have come across one document would be written as a Pasupu Kunkuma gift deed, whether that gift deed, as under 1 section 122 of TP Act, requires registration and stamp duty or not. This controversy went on and ultimately set a trust by the Supreme Court that though it's a traditional form of gift, it requires stamp duty and penalty. It would be excisable to the stamp duty and registration under Transfer of Property Act and Registration Act. That is a different aspect. So, women were entitled to or given only performance of the marriage by spending the amount from the co-partnery. Second one is, some families used to give the traditional gifts like Pasupu Kunkuma. Third one is, women were given the maintenance from out of the assets of the co-partnery. Except that in Mitakshara form, nothing was there for the women. Then come to Dayabhaga. What is it? Dayabhaga, as our friend put it, it was prevailing in mostly in what you call Bengal and Assam. It was altogether a different format. There is nothing like co-partnery. The last male ancestor who was possessing the property, both his individual and the property which he obtained on division with his brothers or father, he was the monarch. He was under the control of that property. He could utilize it the way he liked. He could have alienated or spent it whatever manner he liked. His children, particularly the males, could not have questioned him during his lifetime. Whatever left by him after his death, his sons used to take it. This was the system under Dayabhaga. And in both these systems, if you keenly observe, Mitakshara was regarded as unobstructed heritage. Rather, Dayabhaga was regarded as obstructed heritage. Apratibandhaka, pratibandhaka. Apratibandhaka is unobstructed because in Mitakshara system, a person being born as a male member was enough to confer him certain right, is not it? But in Dayabhaga, so there was no obstruction there. It is only when partition takes place you get. But in Dayabhaga, it was a pratibandhaka. There was an obstruction in the form of the last holder of the property, last ancestor of the property. During his lifetime, none could have claimed or demanded anything. Therefore, his presence is in an obstruction to him. That is why it was regarded as pratibandhaka, obstructive type of heritage. These are the main differences between Mitakshara and Dayabhaga. We were in pre-1956 system. In both the systems, the women were getting nothing. This is the fundamental aspect. This is how the partitions used to take place. Then slowly we have to migrate to 1956. Before that, there is another enactment. There was another enactment. Of course, nowadays, because of the transition, we are now in 2025, and even 1956 enactment is a too old an act, rather around 70 years old. Therefore, prior to that, what enactment was there, probably you may not be required to deal with it, but you have to know it for academic purpose, or sometimes very rarely you may come across any case on that aspect. What is that one? That also you have to know it. This is, as I told, that when even under Mitakshara and Dayabhaga, women was not given any prominent place or share. So some justice has to be done to her. This was considered, but it was the personal law of a community, Hindu community. Even the British rulers did not want to touch it. They never touched the personal laws, neither Hindus nor Muslims nor even Christians or other communities. So we are now concerned with Hindus. But by 1940, the injustice done to the women was so rampant that they considered it required to do some justice to the women. Therefore, and Hindu personal laws needed to be amended, needed to be codified rather. Therefore, a committee was appointed in 1941, Hindu Code Bill Committee. Is not it? You won't get in regular textbooks. You have to read from internet and all this Indian history, freedom history and all this, you will find it. A committee was appointed headed by B.N. Rao, P. Narasimha Rao, Benegal Narasimha Rao, a genius of his kind, who also acted as constitutional advisor to the drafting committee and constituent assembly in the latter years, 1946. Who roamed the entire world with the team and brought important facets of different constitutions of the world. Due process of law under Article 21, is not it? From German and American constituencies, his team visited and studied and brought that concept and placed before the Constituent Assembly, and ultimately drafting committee accepted it, and under Article 21, no person shall be deprived of life and personal liberty except according to the procedure established. There it was due process, where we have amended it and introduced in the form of shall not be denied life and liberty except according to the procedure established by law. So this B.N. Rao committee was also prior to the Constitutional Committee. He was appointed and he was given a team to study the personal law of Hindus and suggest codifications. From 1941 to 44, this committee has studied vigorously what are the various manners in which the women, Hindu women, were suffering. One such aspect is polygamy was prevailing at the time, isn't it? A male person could have married before 1946, I'm telling, could have married more than one woman. That was not a punishable one. I mean, not custom-wise, it was not treated as a ground for divorce also, because even my Hindu Marriage Act was not formed at that time. Similarly, a widow was not permitted usually to take in adoption. This is one more anomaly, they thought, this committee. And most importantly, so far as partition is concerned, women was not given a share at all. Hindu women was not given a share at all. So they thought that certain anomalies should be eradicated and statutes should be made. They have prepared what we are now seeing in the personal codes, 4 enactments, isn't it? Hindu Marriage Act 1955, 1956 Hindu Succession Act, Hindu Adoption and Maintenance Act, Hindu Minority and Guardianships Act. All these were the result of the hard work performed by the committee, BN Rao committee. They placed it before the central government. In the meanwhile, freedom has come. It took some more time. The greats like Ambedkar, who was the first law minister, has proposed to introduce the code bills. But it also took some time, and slowly from in between 1955 and 56, these 4 enactments have come. That is how the Indian woman, I am visualizing the partition firstly in the context of a woman, because she had not been getting anything, she got something. That I wanted to tell you. So 1956 enactment was done, but in between there was another enactment through which a partial justice was done to women, though full justice was not done. Even by 1956 also no full justice was done to her. That's a different aspect. Mitakshara and Dayabhaga system too, we transformed up to 1937 states. 1937, to do some justice to women, they introduced Hindu Women's Right to Property Act. Most of the juniors might not have come across, because they didn't have that necessity or opportunity. But we in our practicing days used to get around 30 or 40 years back. What is this Hindu Women's Right to Property Act 1937? They wanted to do a justice to the entire woman as a community, but a partial justice could be done by virtue of this enactment. What is it? 1937 enactment. Hindu Women's Right to Property Act. What this enactment is? It consists of only 4 sections. Hitherto, nothing was given to women, we studied. But by virtue of this enactment, particularly section 3, it is only consisting of 4 sections, out of which section 3 is the main one. It says that a male person was having, so far as Dayabhaga school is concerned, a male person of Dayabhaga having property in his hands and died, then his sons used to take it. Therefore, a slight amendment was made. So far as his share is concerned, that would devolve on his widow. So widow was given some share of her husband, so far as Dayabhaga is concerned. Coming to Mitakshara. Mitakshara is concerned, again we have 2 types of property. One is the personal property of a male and his share in the co-partnership. In both of them, again they said that so far as his share in the co-partner is concerned, along with the sons, she also would get equal share left by her husband. So far as the self-acquired property also concerned, this is the same principle. So, what her husband used to have in a particular property, in a lighter vein I'm telling, that was conferred on her. You might have thought that if that was the case, she must feel happy. No, it is subjected to subsection 3. Subsection 3 says that what all given under the above 2 subsections was only a limited estate. Is not it? A limited estate means it was given for her life enjoyment without the right to have any alienation. She could enjoy it during her lifetime, but except that it was not her absolute property. She could not have treated it as her absolute property. But hither and there, some decisions you may come across if you wanted to peruse Privy Council decisions and others. For her ailments, means necessity for hospitalization or medicines, etc., or performing the pilgrimage, she could have alienated a part of her estate and she could have gained money. It is only an exception, but generally she didn't have a right to alienate the property. It was purely a life estate. After her death, again it would revert back to in Hindu Mitakshara, it was a co-partners. In the Dayabhaga, it reverted on her sons. Again in the process, neither woman was given a full estate, full right, nor the daughter is considered under Hindu Women's Right to Property Act. Understood? Daughter is nowhere spoken about, even under 1937 Act. Only women, that is a widow, was given a life estate. That is why it was called as Hindu Women's Estate. If you carefully see, 1956 Act, particularly Section 14 of the Hindu Succession Act, it was specifically laid down in Section 14(1) that what all she got it, and she was in possession by the time Hindu Succession Act came into force, that estate is transformed into a full estate or absolute estate. Am I right? So what she got under 1937, and if she preserved it and she was alive as on the date of the Hindu Succession Act, if she was in possession as on that date, then it would be converted into a full estate or absolute estate. This is after 1956 came. But at the stage of 1937, a widow was given a limited estate in respect of her husband's share. It was the concept. But again, I'm telling and repeating it. Women as a daughter, woman as a sister was not given anything, either under Mitakshara, under 1937 enactment. Then we have shifted to 1956. So, friends, I was making a demarcation at the beginning that who were entitled to seek for partition prior to 1956. Obviously, before 1937, it was the male members of the co-personary. And in Dayabhaga, only sons. Women folk were nowhere in this scene. Even after 1937, woman as a widow could get a life estate, though she can claim partition, no doubt. She was given a right to seek for partition, but what she could get is only by way of a limited estate. Am I right? Then we have to go to 1956 phase, a transformation to 1956. That means who are the persons who are entitled to seek partition after 1956. For that, you have to see what is 1956 enactment. 1956, you know, by virtue of Hindu Code Bill was studied, Hindu personal law was studied and divided into 4 different codes, one of which is Hindu Succession Act. Some justice was done not only to a widow, but women as a whole. That means daughter also. Is not it? Even sister also, she will come, of course, as a class to her. That is different. But woman plight was ameliorated to a major extent, though not full extent. What is it? Of the entire 1956 enactment, in the women's angle, we need to see Section 6, is not it? What is Section 6? Any of you? Devolution of interest, isn't it? Yes. If a male Hindu having an interest in the Mitakshara co-personary died intestate, then generally his share used to devolve on by virtue of right of survivorship. Survivorship was not totally taken. For presumptive purpose, it was kept in. If he had no wife or other children, usually sons, and it devolve on co-personary and co-personers will share it. That is one aspect. But it has a proviso to Section 6. This is most important. After 1956, who are entitled to seek for partition? If we put a question, the proviso will give some important answer, provided that that male person who died left behind female heirs in class 1 or male heirs in that class who are claiming through the female, then his share will not devolve by virtue of right of survivorship, but on right of succession. These persons specified in the class 1 will take his interest. This is what the first time in 1956 it was introduced. I will give an example. It does not mean that you do not know, but for your easy comprehension. Prior to 1956, if a male person, suppose a family having father and two brothers, the second brother died prior to 1956. The second brother having two sons and a daughter and wife, his notional share of 1/3 would have been devolved on his remaining two sons only being the co-partners so far as his class is concerned. His wife and daughter could not have got anything. This was prior to 1956. But after 1956, some justification or some justice is done to the women as a wife as well as daughter, that they were put in class 1 heirs, isn't it? So his share, first of all, to be determined, a notional partition has to be introduced because the explanation to section 6 consists of notional partition. So, first of all, his 1/3 share is to be divided between his two sons and him. That means 1/9 each, isn't it? His 1/9 share again to be divided between his wife, daughter, and two sons. So, what the women were ultimately getting, not as a full ownership over the co-partnery in its entirety, like after 2005 amendment, only from his share, they used to succeed being class 1 heirs. Class 1 heirs, if you find it, if you read it, you'll say daughter, son, wife, mother, daughter of a predeceased daughter, son of a predeceased daughter, so on, isn't it? So daughter and mother and wife were also included in the class 1 heirs. By virtue of it, they were getting some share, but not equal share. So far as daughter is concerned, daughter-centric question we put, daughter was not getting full share like that of a son. It's not it. It is only from father's share, along with her brother, mother, she used to get. This is what the system was in 1956. Come to 2005, it is only in 2005 that she was regarded a Hindu co-partnery property, I mean Hindu joint family, Mitakshara Hindu joint family, in a Mitakshara Hindu joint family, on and from the date of Hindu Succession Amendment Act, that is from 9/9/2005. A daughter, three characteristic features were given. A daughter shall have a right in the co-partnery like that of a son. Then she shall be having, of course, all the incidents of rights and liabilities also, if at all any attached to the co-partnery like that of a son, she will be entitled to a full share that of a son, and any liabilities are already attached to it, it will also be attached to her. So a full share is given to her is only from 2005. Of course, state of Andhra Pradesh is concerned, for your convenience. It was introduced, the system was introduced way back in 1986 itself. Act 5 of 1917, if I am right. From 5/9/1985, is not it? It was introduced for the first time in the entire country. It was only the Andhra Pradesh, followed by the Punjab and the Tamil Nadu, if I am right, Maharashtra also. Some states also followed this system. But as a whole, in the entire Hindu Succession Act, this system was introduced on 9/9/95, 2005. Okay, these are the, so when we see who are entitled to partition, the first phase prior to 1937, it was only male members. 1937, widow was introduced with a limited right. Then after 1956, okay, daughter was introduced but not as a full-fledged co-partner, only to get a share in the father's share. But only in 2005, she was getting from then onward, she has been getting the full share along with the sons. This is what the two systems are concerned. Her journey, if we look into in the angle of the women, I mean, most importantly, the daughter. Then some important aspects which have relevancy with the present day, day to day, your what you call practical aspects. I want to discuss few and give some judgments for your convenience. Then leave it to my brother. Some important aspects, ticklish issues we may come across in the course of attending partition suits. Okay? One of them is sometimes the naturally partition suit will be filed by one or two brothers against the father and other brothers, isn't it? Natural, general course, claiming that all the suit properties or plain schedule properties are the ancestral properties, and in which the plaintiffs also have some share as per the facts of that case. And before filing the suit, since sometime prior to it, the other defendants are not rendering accounts or not cooperating with the enjoyment of the plaintiffs, etc. Some ruffles have come, therefore they filed the partition suit. General lines partition suit would be like this. The defendants, what would be the general type of defense we may come across in partition suits? If it is the defendants, sometimes one of the defense is that, yes please. Oh yes, not only nature, some other aspects also. One of the, yes, nature of the property also they may take. It is all a factual aspect we are only visualizing. Okay? One of such defenses is that the plaintiff has already divided, they do not dispute with regard to the properties or legal relationship. The dispute is only with regard to the plaintiff who has already been separated and he is enjoying his share. The properties which are now shown in the plain schedule are their properties, and therefore he cannot claim any share. This is one type of plea we may come across. Then what the loss is, the burden is on whom is the question, is not it? The laid down decisions, the series of decisions would say that first of all, of course, if the relationship and existence of the property is not in dispute, the burden will be on the defendant to establish that there was already a partition, is not it? Why? Because under law, the presumption is that a family, if it is claimed that it is a joint, the preliminary presumption, that is, means a rebuttable presumption, may call it, that there is it is a joint family. The court will, for the first blush, agree that it is a joint family. If a person pleads that, if a defendant rather pleads that it was already severed, then the burden will be on the defendants to establish that already there was a division to non-suit the plaintiff. This is what the number of judgments you may record, note down if you want. AR 1971 Supreme Court, from that stage onwards, AR 1971 Supreme Court 1962, Indra Narayan versus Roop Narayan. So mainly it was held, there are other decisions, but it was a prominent one at that time. So I wanted to share with you. So the person who claims that there was already partition, that person, if he is a defendant, is a defendant. If the plaintiff, in a case, plaintiff, whoever pleads it, he has to establish with regard to the factum of partition. This is one type of case we may come across. Sometimes we may also come across a different type of situation. Some sons or all the sons will file a suit against the father and one or two brothers also, claiming, seeking partition This is general aspect. In that partition suit, they may also plead that so and so properties, plain schedule లో కొన్ని or ఒక ప్రత్యేకమైన classified properties. These properties which were alienated by our father, not for the joint family requirement, though he was a karta, he has not alienated for the welfare of the family, but it was for the purpose of his vices. We will come across, isn't it? Therefore, those alienations cannot be recognized or valid under law. Sometimes they seek for cancellation of those sale deeds and for partition. Sometimes they will ignore by way of pleadings and seek for partition. Okay, whatever it be, the situation is that the plaintiffs claim that some of the alienations made by the karta, father naturally, or brother, eldest brother who happened to be the karta, alienated those properties for his vices, means for yasna. Therefore, they should be ignored or cancellation has to be effected and partition should be made. The counterclaim naturally will be the twofold. One is the karta may claim that what all the properties I have sold or myself have kept properties where the plaintiffs cannot question them. This is one type of plea. Other type of plea is that no, these properties no doubt are the joint family properties, but I sold them for the purpose of joint family welfare and needs, not for my vices. This may be another type. But in this type of cases, what is the law on this aspect is the question. Upon whom the burden will be is the question. The law says that, judgment law, the judicial pronouncements have given two important burdens on the plaintiffs. The burden is on the plaintiffs to say that or establish by way of cogitable, acceptable evidence that the alienation is for illegal purposes or for vices of the father. This is one thing. Second aspect is also the purchaser who purchased those properties purchased them knowing fully well that his father was selling it not for joint family requirements, only for the purpose of his own vices. These two aspects have to be established clearly for the appreciation of the court. Otherwise, the court cannot set aside those sales or ignore those sales. This one. Specifically, it was held by the Supreme Court that it is not sufficient to prove that the father has alienated, but illegal purpose must be pleaded and proved merely because the father or the karta has sold it for luxuries. That cannot be a ground to set aside the sale debt. Please understand, the luxury is different from a vice or legal purpose. Understood? Luxury is different from a vice. A father, let us say a school teacher or a small employee was there. He was the karta, hand to mouth man. He was having some immovable property like a house or a land. He sold that land and purchased a car. A car for their family may happen to be a luxury, but it cannot be, in the eye of law, it cannot be stated as an illegality or for the vice of the father. So you understood the distinction between vice and luxury. If it was purely for luxury, it cannot be stated. The court said that the court cannot sit on the mind of the father to think whether it is a luxury or necessity. If it is only purely a vice or illegal purpose, then only it can be set aside. You can note down our High Court decision based on the Supreme Court judgments 2016, Volume 5, ALT 295. Palaparthi Manikyam versus Palaparthi Venkata Satyanarayana. Of course, incidentally, this judgment was given by me in the Common High Court, referring to the Supreme Court judgments on this subject. So, 2016, Volume 5, ALT, page 295. Palaparthi Manikyam versus Palaparthi Venkata Satyanarayana. In this, Supreme Court judgments are also there. It is a reported judgment, you can verify if you want. So my emphasis is that mere proving that alienation not exactly for welfare of the family is not sufficient. It should be proved to the satisfaction of the court that it is for a particular vice or illegality. That must be established. Another aspect, important one. We have seen, or we are seeing also, a son going for adoption, and adoptive son files a suit for partition against his adoptive father because his ties or relationship is severed from the natural family and established and supplanted in the adoptive family. Sometimes in such a suit, the adoptive father may claim that, no, he is not my adopted son. He is only a foster for some time because we didn't have the children. We brought our relations or our servants' child and we educated them, but we have not adopted them. This may be one type of plea. In such a case, obviously, the burden lies on the plaintiff to first of all establish the adoption, and also secondary aspect depending upon the factual, whether the properties are there or not, whether he is entitled to properties, a share, these aspects. So basically, if the adoption is denied, the primary burden is on the plaintiffs to establish his case. This is not a difficult one. Sometimes we will come across another ticklish issue. A boy goes in, boy or girl, whatever, a boy, let us take. A girl now by virtue of 2005 amendment also. A boy goes in adoption to another family and files a suit for partition in respect of the properties in his natural family. Have you ever come across such a situation? Try to, pardon? Yes, the question is whether he could have claimed a share in the co-personary, erstwhile co-personary or co-personary of his erstwhile natural family. This is. But what is interesting is, in what context such a claim is put, what are the different, in what manner different high courts have dealt with this issue, particularly our high court, I mean common high court. Section 12 of Hindu Adoption and Maintenance Act is very important in this regard to decide whether he could have claimed a right in his natural family as a co-partner. Section 12 says that, plainly it says that with the adoption, all his relationship will be severed from the natural family and established in the adoptive family. This is one thing. But it has an exception in the form of subsection 2. 2 exceptions are there. One of such first exception is section 12, I am saying. The adoptive person cannot marry a person whom he could not have married had there been no adoption. అంటే ఒక బాయ్ ఉంటాడు, అతను అడాప్షన్ అయి వెళ్ళిపోతాడు. న్యాచురల్ ఫ్యామిలీలో ఉండగా ఒక అమ్మాయి అతనికి చెల్లెలు అవుతుంది, అక్కయ్య అవుతుంది. Merely because it was an adoption, he cannot even also now marry because that prohibited degree of relationship continues. It's a morality and other aspects are involved in. This is first exception. The second one is, that is most relevant for us. A property is vested in him, a right vested in him cannot be divested by virtue of this adoption. Once vested, it cannot be divested. This, the adoptive boy wanted to take advantage of. Once vested means, while I was in my natural family, I was a co-partner. Subsequently, I was given adoption. That co-partner right is a vested right which cannot be divested merely because I was given in adoption. Therefore, I will get two rights. One is natural family, another is adoptive family. This is the line of argument. But most of the courts, high courts, taking a cue from the Supreme Court. Supreme Court directly on this aspect has not pronounced, but incidentally held in a decision that with the adoption, all his relationships, not specifically in the context of claiming partition, it was not that decision. But in a general context, it was observed by the Supreme Court that with the adoption, all his relationships which were there in the natural family will be severed and established in the adoptive family. Taking a cue from that judgment, the judgment for your appreciation, I may give it. Manu SC, Manu decision, Manu Patra decision only I got it. Manu SC 0296/1969. Srimati Sitabai versus Ramchandra. In this decision, they held that with adoption, all his ties or relationship with the natural family will be severed and established or rooted in the adoptive family. Taking a cue from it and also interpreting section 12b, subsection B of subsection 2, various high courts held that a right in the co-personary is not a vested right. This is most important observation. Bombay, Karnataka, Madhya Pradesh, and some other high courts, I will give you a few judgments. They have regarded that what is the right in the co-personary? You being a member of the co-personal, you will right is to have a joint enjoyment along with other co-personals. This joint enjoyment is a fluctuating interest. With the increase in the births, your right will be diminished. With the deaths, it may go up. So you cannot claim any definite share till actual partition takes place. It's not it. And furthermore, Karta could have alienated for the welfare of the joint family. Or family itself, by an understanding, can alienate the properties. So it all depends upon so many ifs and buts. Therefore, that right in the co-personality cannot be claimed as a vested right in the joint, in the co-personality. If that is not a vested right, if we cannot treat it as a vested right, the question of it being not divested under subsection 2b does not arise. That means with the adoption, you lost all your rights in the natural family. You cannot claim, you cannot have a cake and eat it too, that is what. So you cannot claim any right in the natural family. These type of decisions, pardon? Yeah.
Suppose in the adopted father's property, prior to his adoption itself, ancestral property was sold. Can he claim right in that property, the adopted son?
Ancestral property was sold.
Sold. Prior to his adoption, the adopted father has already sold the ancestral property. Can the adopted son question, after the adoption, can he question?
Cannot. He cannot. I'm first of all giving the decisions, and then I may further one or two aspects governing this one. One is Manu. Please, any doubt or question? Manu, SC. Yes, please. For the convenience of all of us, you can give a right.
One submission, sir.
Please.
Prior to 1956, age adoption from the one male child is also eligible for the right for the original sons and
Pardon? Prior to 1956.
Yeah, he adoption from male child. Naturally, natural sons in the age again.
It's a loud guy. I'm unable to catch up your question. Prior to 1956, a boy was given in adoption. Now?
తర్వాత ఆయనకి మళ్ళా పిల్లలు పుట్టారండి.
ఎవరికి? అతనికి.
అతనికి మళ్ళీ ఏ బీలో ఇద్దరు పిల్లలు పుట్టారు.
ఓకే.
ఆ ఇద్దరు పిల్లలతో పాటు అతను కూడా ఎలిజిబిలిటీ ఉంటుందండి రైట్ ప్రాపర్టీలో.
ఏ ప్రాపర్టీలో మీరు అడుగుతున్నది?
ఫాదర్ ఎలా చూస్ చేసుకున్న దాంట్లో హిందీ సక్సెషన్ యాక్ట్లను రైట్ ఉంటుందా అని. పార్టీషన్
ఒక బాయ్ అడాప్షన్ వెళ్ళిపోయాడు 1956. ఆ తర్వాత ఎవరికి న్యాచురల్ ఫాదర్కి చిల్డ్రన్ పుట్టారనా?
న్యాచురల్ ఫాదర్
పుట్టారు, వాళ్ళు కోపర్సనరీ కంటిన్యూ అవుతారు అంతే. ఈ అడాప్టివ్ బాయ్ వెళ్ళిపోయిన అతనికి ఏమీ ఉండదు, అది అంతే.
అతను కూడా రైట్ ఉంటుందేమో.
లేదు, ఉండదేమో. ఉండదని హైకోర్టు సుప్రీంకోర్టు అంటున్నారు అంతే. మీ క్వశ్చన్ నేను సరిగా అర్థం చేసుకున్నాను. ప్లీజ్ బేర్ విత్. అడాప్షన్ ఒక బాయ్ వెళ్ళిపోయాడు 1956 ముందర. తర్వాత న్యాచురల్ పేరెంట్స్కి పిల్లలు పుట్టారు. ఆ పిల్లలతో 1956 అయితే ఓన్లీ మగ పిల్లలు, ఆ తండ్రి న్యాచురల్గా ఒక కోపాసనరీ కంటిన్యూ అవుతుంది అంతే. ఈ వెళ్ళిపోయిన బాయ్ ఏ రైట్ న్యాచురల్ ఫ్యామిలీలో ఉండదనే ఇప్పుడు ఈ జడ్జిమెంట్ తాలూకా సారాంశం అన్నమాట. అది
అడాప్షన్ తీసుకున్నాడు సార్ అప్లైంది. అడాప్షన్ తీసుకున్న తర్వాత ఆయన పిల్లలు పుట్టారండి.
మీరు అంటున్నది అడాప్షన్ ఇచ్చిన ఆయనకు పుట్టారా? ఎవరికి పుట్టిస్తారు? తీసుకున్న ఆయనకి వస్తారు, వాళ్ళు కూడా కాన్స్టిట్యూట్ అవుతారు, వాళ్ళు కూడా కోపాసనలో చేరుతారు.
అందులో 1/7 షేర్ ఉన్నారు తప్ప 50% షేర్ లేదంటున్నారు సార్.
1/7 అని మీరు ఏదైనా పెండింగ్ కేసు గురించి చెప్తున్నారా లేకపోతే? అయ్యా, ఎగ్జాంపుల్ ఈజ్ సో సింపుల్. ప్లీజ్, వీఆర్ రన్నింగ్ షార్ట్ ఆఫ్ టైమ్. మై బ్రదర్ హ్యాస్ టు గివ్ హిస్ సి 2 ఎగ్జాంపుల్స్. మీరు అడిగిన ఎగ్జాంపుల్ అడిగింది కూడా చెప్తున్నాను. ఒకవేళ అడాప్షన్ ఇచ్చేసిన తర్వాత న్యాచురల్ ఫాదర్కి మదర్కి చిల్డ్రన్ పుడితే వాళ్ళు ఒక కోపాసనరీగా కాన్స్టిట్యూట్ అవుతారు, కానీ అది వాళ్ళు పంచుకుంటారు. ఈ వెళ్ళిపోయిన అతనికి ఏ రకమైనటువంటి రైట్ ఉండదు. ఇది ఈ జిస్ట్ ఆఫ్ ది డెసిషన్స్. రెండో ఎగ్జాంపుల్, అడాప్షన్ తీసుకున్న తర్వాత బై గాడ్స్ గ్రేస్ అడాప్టివ్ పేరెంట్స్కి చిల్డ్రన్ పుట్టాడు, వాళ్ళకి రైట్ ఉంటుంది, వాళ్ళ రైట్ ఎక్కడికి పోదు. అడాప్షన్ వెళ్ళిన ఆయనకి కూడా ఉంటుంది, ఆయనది తప్పు లేదు. కాబట్టి తప్పంతా ఎవరిది లేదు. అది ఇప్పుడు ఐవీఎఫ్ ఐయుఐ అన్నీ కూడా వచ్చిన తర్వాత పిల్లలు పుట్టడం కష్టం కాదు.
One widow adopted one son. After that, she remarried to another person. Now that that person passed away. Now that son, adopted son, will inherit the properties of the second husband. Because of doctrine of relation back, he is the son of the ex-husband, not the next one. Right? So, will he inherit the property?
ఆవిడ ఎప్పుడు అడాప్ట్ చేసుకుంది? రెండో మ్యారేజ్ చేసుకోక ముందే. డాక్ట్రిన్ ఆఫ్ రిలేషన్ బ్యాక్ టు వ్యూ ది లీగల్ స్టేటస్ టు దట్ బాయ్. డాక్ట్రిన్ ఆఫ్ రిలేషన్ బ్యాక్ ఎందుకన్నారు? అడాప్షన్ చేసుకున్నది ఆ భర్త బతుకున్న టైం నాటికే, అట్లీస్ట్ ఆన్ ది డేట్ ఆఫ్ డెత్ నాటికే తను ఆయన ద్వారా పుట్టినట్టు, అంటే లీగాలిటీ ఇవ్వడానికి వస్తున్నాయి తప్ప ఆయన రైట్ని పోగొట్టడానికి మాత్రం కాదు. అది హీ విల్ బి ఎ వ్యాలిడ్ బాయ్.
First husband is ex, second husband is wife, but he is son of the ex only, right? But will he inherit the properties of wife?
Certainly. He is the legal for all practical purposes. He will be.
Sir, ఎన్ని జనరేషన్స్ ఉంటే అది యాన్సెస్ట్రల్ ప్రాపర్టీ అంటే గ్రాండ్ ఫాదర్
ఫోర్ జనరేషన్స్. కామన్ ఏ, ఆయన కొడుకు బి, ఆయన కొడుకు సి, ఆయన కొడుకు డి.
గ్రాండ్ ఫాదర్ యాజ్ యాన్సెస్ట్రల్ ప్రాపర్టీ. మనవాడికి ఆస్తి అట్లా యాన్సెస్ట్రల్గా ట్రీట్ చేయాల్సిన పని లేదు. మనవాడు గ్రాండ్ సన్ తాత ఆస్తిలో వాటా ఉంటుంది అనుకుంటారు కదా.
తాత ఆస్తిలో వాటా ఉంటుందని స్ట్రైట్ క్వశ్చన్కి మనం ఇది ఇవ్వలేము. అన్లెస్ సమ్ ఫ్యాక్ట్స్. ఇంకా తాతకి కొడుకుల మధ్యన ఉంటే మనవడికి రాదు, మా నాయనకి వచ్చిన దాంట్లో ఇంక వస్తుంది. అది
నాయనకి వచ్చింది కూడా నాయన అమ్ముకున్నాడు అనుకోండి. అప్పుడు
మరి ఇంకా తాత దాంట్లో ఇంక వచ్చేది ఏముంటుంది? తాతది డైరెక్ట్గా రాదండి. అదే మనం తాత దగ్గర నుంచి ఆయన కొడుకులకు వస్తుంది, ఆయన కొడుకులు వచ్చిన దాంట్లో వీళ్ళ నాన్నకు వచ్చిన దాంట్లో మళ్ళీ ఈయన వీళ్ళందరికీ వస్తుంది.
నాన్న ఫ్రీగా అమ్ముకోవచ్చు, ఫాదర్ ఏమైనా అమ్ముకోవచ్చు.
ఫాదర్ ఎప్పుడు అమ్ముకోవచ్చు అంటే తాత దగ్గర నుంచి వచ్చినప్పటికీ వీళ్ళకి పిల్లలు లేకపోతే అమ్ముకోవచ్చు. పిల్లలు పుట్టక ముందే అమ్ముకుంటే అది వ్యాలిడ్. పిల్లలు పుట్టిన తర్వాత అయితే అది కోపర్సనరీ ప్రాపర్టీగా రూపాంతరం చెందుతుంది. అప్పుడు అమ్మలేడు. అమ్మితే వ్యాలిడ్ పర్పస్ కోసం అమ్మితేనే అవుతుంది. అది. So my request is, we are running short of time, and please don't put a question which you are doing in the form of a case, because it needs some, no, it's not a fault in asking it. Purely legal aspect మీద అయితే మనం వెంటనే చేయగలం, లేకపోతే కొన్ని ఫ్యాక్ట్స్ లేకుండా కరెక్ట్గా డిస్కస్ చేయడం కుదరదు అన్నమాట. ది కాన్సెప్ట్ హియర్ అడాప్షన్ ఏంటంటే, a adoptive boy went into the adoptive parents, whether he can claim a right in the natural family, and series of decisions which I have discussed. Manu SC into me చెప్పలేదు మరొక 2 decisions. There we are. I close it within 5 minutes. Manu SC 2803/2005. Basavarajappa versus Guru Basamma. అలాగే AR 1992 Bombay, page 189, Devagonda Rayagonda Patil, DR Patil versus SR Patil. All these decisions, another only one Patna decision, AR 2001 Patna 125, SK J Jalal versus Chandrakishore Jalal. All these decisions are on the point that a right in the co-personary is not a vested right, they treated it. It is only a right of enjoyment till partition took place. So when you are adopted to some third party, adopted by a third party, your right in the co-personary cannot be regarded as a vested right so as to claim a right. This is the fundamental aspect. Okkati. But a different type of decision was given by our own High Court. That you have to note it. AR 1981 AP, page 19. AR 1981 AP, page 19. Yarlagadda Naidamma and others versus Government of AP. It is in this decision, it was held in a different manner. AR 1981 AP, page 19. In a different manner it was treated, the same problem. No, it is a vested right. A right in the co-custody of a natural family is a vested right. It can be carried to the adoptive family also. Therefore, adoptive child can claim, adoptive son in that case, can claim a right in the original family also. Of course, I must quickly add that this opinion arrived at by a land single judge was based on the commentary of a commentator, had not taken into consideration the Supreme Court judgment of 1969, wherein the Supreme Court, of course in a different context, observed that with the adoption, all relations will be severed. Okay? Therefore, I leave it for your study and utilizing these decisions. I can't suggest you which decision you have to apply. But different high courts, basing on Supreme Court's earlier judgment of 69, observed that no, it is not a vested right. But AP High Court, the land single judge, observed that it is a vested right. I leave it to you. One more and I will close. This is one controversial aspect. Of course, third party rights. We were dealing with the third party. Second aspect is third party right, isn't it? Third party right. Actually, prior to in 1956 days, a co-partner could not have alienated his share or any definite property in the co-partnership. But all the members by an agreement could have, or with the consent of other members, he could have alienated. But without that, of his own interest, he could not have alienated it. Even after 1956, as per section 30, he could have executed what? It is a testament will, so far as his share is concerned, undivided share is concerned. This is the legal position, but in practical situation, we will come across sometimes a co-partner sometimes alienates his undivided share. Sometimes very strangely alienates a particular property in the co-personary for his requirements. Maybe lawful purpose, but without the consent of other co-partners, etc., he alienates it. Then what is the right of the third party purchaser is the question. The law is that third party purchaser cannot claim any right over the property, and he cannot sometimes claim joint possession along with the other co-partners also in respect of the property which he purchased. Then what is his right? His right is always for praying for equity, equitable relief. That means he can file a partition suit requesting the court to partition the properties of the joint family and allot that property which he purchased to his vendor and then deliver that property. It is a lengthy process and purely depending upon the equity. Equity means a request type. Or already a partition suit is pending in the court, there he can join as a third party purchaser, making again the same request. That property may be, which he purchased, may be allotted to his vendor and may be allotted to him ultimately. The court may, depending upon the facts and other findings, accede to his request or it may reject his request, and his relief is against his vendor but not others. Therefore, these type of judgments we have, please take note of it, one or two. AR 2008, Supreme Court, page 2489. Hardev Roy versus Shakuntala Devi. Another judgment also from Andhra Pradesh, which was AR 2009, Supreme Court, 2141. Pitani Suryanarayana versus Repaka Venkataramana Kishore. So this is with regard to third party purchases right. Then the last one is, of course, there are others for paucity of time I cannot deal with, particularly with regard to the rights of the illegitimate children and all this. Law is settled recently, you might have come across. But one important aspect is procedural one. Third component is, in our case, who are entitled to seek for partition prior and subsequent to 56 and 2005. That is one aspect we have discussed, practical things. The second one is the rights and liabilities of the third party purchaser, and third one is with regard to the final decree petitions. Hitherto, or at least a decade back, invariably all of us, even in our practicing days and even your practicing days, used to file final decree petition after a preliminary decree was passed, isn't it? Treating that, even the courts were treating it as preliminary decree, rights are defined, there ends the matter, the judge will stop the proceedings there. Again, you used to file an IA for passing of the final decree, another IA for appointment of advocate commissioner to evaluate the mean profits, so on and so forth. But the Supreme Court's observation, in the Supreme Court's concept, what the final decree petition is, it alien to the preliminary decree. The Supreme Court has observed it. For those who already know these judgments, well and good. For those who have not come across, please note them. The Supreme Court held that final decree is not an alien to the preliminary decree, and the courts, it is a court-centric judgment. The court's responsibility-centric judgment. This court's responsibility is not completed by merely passing the preliminary decree. The party who has knocked the doors of the courts has not come only to be satisfied with a preliminary decree. He wanted ultimate fruits of the decree. That means actual partition by metes and bounds and to give back his share. So in that context, he need not be asked to nudge the judge or the court again to pass a final decree by filing a final decree petition. It is the duty of the court to continue the proceedings. This is what important. The court has to continue the proceedings in the form of even after preliminary decree and complete the proceedings. This judgment was rendered in the context whether there was any limitation for filing decree petition. That aspect was also discussed by the Supreme Court twice. Please note down. please. 2009, Volume 9 Supreme Court cases, page 689, Shah Karan Bubna versus Sita Karan Bubna. It's only 2 sentences it was observed, but very poignantly the Supreme Court has observed. I will quote, when a preliminary decree is passed in a partition suit, the proceedings should be continued by fixing dates for further proceedings till a final decree is passed. It is the duty and function of the court. Performance of such function does not require a reminder or a nudge from the litigant. The mindset should be stop, expedite the process of dispute resolution. So it is the duty of the court to continue the proceedings. The same judgment was again reiterated in the latest judgment 2022, Volume 7, SCR, Supreme Court review, I suppose. SCR, page 1120. Parties I have not noted, sorry. 2022, Volume 7, SCR, page 1120. So, if you file final decree petition or not is not the question. The court's duty is to continue the proceedings. So, in that context, one cannot say that there is any limitation for filing the final decree. That aspect is also discussed. Please read for your comprehension. These are the aspects which I thought that there are few aspects, of course, you must be awaiting, but there is no time for us to discuss with regard to 2005 when the daughter can claim, if a father died even prior to 2005, whether she can claim a share or not. The law is well settled with Vinit Sharma's decision. Most of you might have known. I wanted to discuss, but there's no time. I request my brother to continue and add important aspects on this.
Thank you, sir, for your presentation on the subject. It's very informative and it is well received by all the persons who gathered. Now, felicitations to the chief guest.
On behalf of the organizers and all the participants, I extend our deepest gratitude to Honorable Justice Durga Prasad Rao Garu for his insightful and enriching session. We sincerely thank for your gracious presence and making the time to engage with us. It was indeed been an honor. Thank you.
Hello, my dear advocates. The Honorable Judge who spoke just now and presented a subject on this particular aspect want to leave. That's why the next speaker is here. I just introduced you Satya Rao Garu, former Principal District Session Judge, Visakhapatnam. We'll speak on the law of the testamentary and interstate succession and the Hindu joint family.
Respected dignitaries on the dais, members of the Bar Council and President of the Bar Council of Andhra Pradesh, respected advocates and court officers, and students of Damodaram Sanjeevaya National Law College. Good evening, everybody. I know that it is very daunting and difficult task to speak after having a vibrant discourse, a felt speech made by His Lordship, Sri Durga Prasad. But I am sure that I will not let you feel bored, and I will not let you feel that God be hammered down. Gentlemen, law is experience of life. Unless we have abundant common sense of reading men and material, it is not possible to perceive the ramifications of law. Just to bring Vivaldi, after hearing seriously both pragmatic and dogmatic, a seamless blend of lecture consisting of pragmatic and dogmatic knowledge, I try to share with you the information of Sri Maruti Rao, Golapudi Maruti Prasad. On one occasion, while contributing his article to Hans India as a columnist, he shared the weird information sent to him by email by one of his friends. As per the said information, it is a small story that 3 old men have gone to see the God. One is American, the other is Russian, and the third one is Indian. American asked the God, when my country will come out of recession. God said, it may be 50 years. The senior citizen, being aged 70, wept like anything because by that time he may not be alive. Then Russian questioned the God, when my country will come out of recession. God said this time, maybe 100 years. Russian also wept like anything because by that time he may not be alive. And the turn came to India. He posed a question which is somewhat perplexing and flummoxed, stating, when my country will become litigation free. This time God wept like anything, saying that I may not be alive by that time. So, unless we are thorough, of course it is a joke, but the seriousness that latently lies in the story is being court officers, advocates being court officers, unless we are thorough with the subject, or at least have the penchant to know the niceties. Sometimes it may spell disaster, because it is the drafting that makes the difference. Unless your drafting reflects the emphasis of the words, there is every possibility of miscarriage of justice. You know, the words enacted in a law come from the mint of the legislature. They carry different denominations on different occasions. They do not carry similar denomination all the time, all the way. So first of all, we must know the Act 39 of 2005 amendment was enacted with a lofty idea to bring parity of rights in between the men and women. The scheme and object of the enactment is such. And the second one is whether this enactment is made to bring equality or equity. Whether this enactment is a watershed in the annals of history of legislation regarding Hindu law. You know, I belong to X generation, some of you belong to Y generation, and most of you belong to Z generation, and a few of you belong to Alpha generation. As far as X generation and Y generation, there is no problem. The Z generation and alpha generation in the entire world, they do not care about the equality. They have been stressing for equity. What do you mean by equity? The women in the entire world, and in fact it is the buzzword, equity is the buzzword, demanding, we are not demanding equality, we are demanding equity. Equity means a fair and reasonable treatment. How come a man is treated in the society, we want the same treatment in the society? Yes, it is justified. Whether this law has been progressing towards that way, or it has been progressing towards striking to create equal rights on par with men. Okay, leave about it. So far we had many things. What do you mean by metakshara? What do you mean by co-partitionary? What do you mean by ancestral property? What do you mean by obstructed heritage? What do you mean by unobstructed heritage? And for that matter, what do you mean by Hindu? These are all the words staring at us for proper answers. And what do you mean by succession and inheritance? Whether the Hindu Succession Act 1956, the title is correct, or whether there is a red herring in the enactment. So to start with, if you carefully read the long cause title of the enactment, in the very first sentence it is there, an act to amend and codify the law relating to interstate succession among Hindus. So the long cause title is not Hindu Succession Act, it is interstate succession. Then what is the difference between testate succession, interstate succession and Hindu Succession Act? These are the questions. Unless we are thorough with these points, it is difficult to come to a conclusion. So as you know, laws may be either personal or territorial. Personal laws are applicable to people of a particular religion, and hence in India, people of different religions are being governed by their respective personal laws. For example, in case of a Hindu, he is being governed by Hindu Interstate Succession or the Succession Act 1956. In case of a Muslim, he is being governed by Muslim law of inheritance, not Muslim law of succession. And in case of Christians, sections 39 to 48 Indian Succession Act. So unlike personal laws, territorial laws are different, and they apply to the people of entire territory or the country, irrespective of their religion. The best example is Transfer of Property Act. When a property is transferred, mobile property is transferred from one living person to another living person, the law to settle the dispute is applicable is Sale of Goods Act. When immovable property is sold, in between the persons and the divorce, the law applicable is Transfer of Property. And in both the cases, the persons must be alike. And the only exception is Hindu Succession Act, or Muslim Succession Act, or Indian Succession Act, that a property devolves, which is typically belonging to a dead person, to a living person, by conferring title or right in that person. So it is a transfer of property in between a living person and dead person, and the personal law applicable is Hindu Succession Act. Again, Hindu Succession Act consists of two parts, that is testamentary section and interstate section. Testamentary section is very simple, that a person dies by leaving a testament, that is a will. It is known as testamentary section. And the property left behind him after his death will be distributed among his legal heirs as per the terms of the recitals of the bill. Intestate section is the section whereunder his legal heirs are entitled. Then inheritance and succession are two different aspects. In the right of the conflicting views, I would like to shed light on the cliched views of Hindu law in the teeth of Section 4 of Hindu Section Act 1956 and Act 39 of 2005. So, Hindu law, the old Hindu law, which we call uncodified law, and the new law is codified law, that is the 1956 Act as well as Act 39 of 2005. The old Hindu law which remained in force immediately before the commencement of Act Hindu Section Act 1956 and Act 39 of 2005 shall cease to have the effect on all the matters for which a provision is made in the codified law. Thus, the legislature rightly omitted the antediluvian theories relating to the old Hindu law, but still there are certain aspects which are left uncovered in the Act 39 of 2005 and in the Act Hindu Section Act 1956. Take for example the basic tenets, Metakshara, Dayabhaga, obstructed heritage, unobstructed heritage, and ancestral property, co-portionary property, joint family property. We do not find the definition of these words in the codified law. We have to fall back on the uncodified law. So unless we have a comprehensive idea and perception about these words, we cannot comprehensively come to a conclusion about the various provisions enacted in Hindu Section Act 1956 and Act 39 of 2005. Take for example, even the word Hindu is not strictly defined under Section 2 of Hindu Section Act in terms of religion. India is not an exclusive term of Hindus, wherein some are Hindus, some are Muslims, some are Christians, some are Persians, so on and so forth. For the first time, the Honorable Apex Court had the occasion to define the word Hindu while deciding the case law in between Satri Yajnapurusharji and others versus Moldas, Brodabdas, Vaishya and another, reported in AR 1966 Supreme Court, page 1119. There the point came because the plaintiffs in the suit filed a representative suit for declaration before the trial court on the ground that in Bombay, the Harijan Temple Century Act 1947, Amendment Act 1948 is allowing Harijans into the temple, and whereas Swami Narayana sect, we belong to Swami Narayana sect, and it doesn't come under the definition of Hindu, and we do not follow Hindu religion, so we may be exempted, and that act is not applicable to Swami Narayana sect. The trial court decreed the suit. They preferred appeal. High Court set aside the decree and allowed the appeal. Then they went to Supreme Court. For the first time, Supreme Court defined that the word Hindu was derived from the word Sindhu, a river which is known as Indus, which flows from Punjab. The people, that great Aryan race, which immigrated from Central Asia through the mountains and passes into India
and settled in the drained parts of the river Sindhu. The Persians and Western invaders used to call them as Hindus, and the traditions and conventions they follow as Hinduism. Eventually, it has become Hindu and Hinduism. And these are the words set by the apex court, and even as per the former President Radhakrishnan also, the word Hindu had territorial significance, rather cradle significance or a religious significance. It has no religious significance, it has a territorial significance. Hindu means a residence in a well-defined geographical area. So, a topography relates to word Hindu and not a religion. And the apex court didn't stop there, and it has gone to an extent that aboriginal tribes of civilized people, savages, cultured Dravidians, and Vedic Aryans are all Hindus. Of course, though it is not impossible, but it is difficult to define the Hindu religion, because Hindu religion doesn't claim any prophet. It doesn't worship any one God. It doesn't subscribe to any one dogma. And it doesn't believe in any one philosophical concept. And it follows different sets of religious practices. And totally, Hinduism is a way of life. Both, it has great amplitude. It is both plastic and elastic. This is the kernel of the observation made by the Honorable Supreme Court in that edition. Now, coming to various sources of law, how the Hindu jurisprudence has evolved means the main sources of law are Vedas, Smriti, and custom. Vedas do not have any jurisprudence, legal jurisprudence. They consist of Shruti and Smriti. Shruti doesn't deal with any positive legal lawyer's jurisprudence, and whereas Smritis are considered by the Hindus as Dharmasastras, the very foundation of Hindu jurisprudence. So the people who shed light on Smritis are known as Smritikars. Narada Smriti, Yajnavalkya Smriti, Jimota Vahana Smriti, Manusmriti. And the result is that two schools sprang from these Smritis. One is Mitakshara and the other is Dayabhara. Now, can I request anybody, what do you mean by Mitakshara? Because we use the word Mitakshara, and even in the enactment 39 of 2005, the word Mitakshara is there. What do you mean by Mitakshara? Anybody? You click the Google. Mitakshara is a compendium, a brief compendium or a digest which depicts about the works done by Yajnavalkya. So it is a brief running commentary on the works done by Smritikar Yajnavalkya, and it is a compendium, a brief compendium, Mitakshara. So also Dayabhaga is a brief compendium on the works done by Jimotavahana, a Smritika. They are not schools, but we call them as schools. That's why I am asking you, try to understand the emphasis of the words. Then, the chief difference between Mitakshara and Dayabhaga is, in Mitakshara, blood is preferred to community while offering religious oblations. So if I want to offer a particular prayer before a god, I must be from a particular family. I must have some consanguine relationship with that family, a blood relationship with that family. Community is not important. Whereas
In Dayavaga, it is the spiritual efficacy that is the criterion and not the blood relationship. And the another difference is that the son have a right by birth. As far as Metaksha is concerned, whereas son gets a right after the death of father, as far as Daibaga school is concerned. That's why Metaksha holds a sovereign sway over the entire India except West Bengal and Assam. Now, what do you mean by succession and inheritance? Anybody? What is the meaning of succession? Day in and day out. We use it to talk about succession and inheritance. No. Beating the egg. Dispel all those ideas. They are not correct. They are incorrect. Both succession and inheritance in Hindu jurisprudence are distinct concepts, though they appear to be and deal with the property of a deceased person. Passing of the property and the journey is the same, but there is a typical difference in between these two, because succession establishes a procedure determining how come the estate of the deceased shall devolve and who are the rightful legal heirs and in what proportions that property should devolve. So this is a procedure established by a succession. Whereas inheritance means actual receiving of the property after determination of your rights, as established in the succession. So there is a lot of difference. Succession is the tree, inheritance is the branch. So this is the chief difference between these two. Then, what do you mean by proportionary, joint family, and ancestral property? Can anybody say about ancestral property? Can any one among you give a clue to me about ancestral property?
From 4th generation, the property should be without any relation, it should be passed. That is called ancestral property.
Please. Anybody? I can understand. So, gentlemen, unless you go through the commentary, it is not that much easy. Why the two clashing judgments of equal strength of the benches of Supreme Court troubled the litigant public and the advocates for a span of half decade, Pulavati case and Danama case. For 5 years, we troubled like anything. No, I will come. First of all, I would like to define what do you mean by joint family. Joint family consists of lineal descendants from a common ancestor, including their wives and unmarried daughters. Including their wives and unmarried daughters. Is it not the time to redefine the joint family, because Act 39 of 2005 elevated the unmarried daughter or a daughter, for that matter daughter, to the status of a co-partner. So now we have to redefine the definition of joint family, which finds place in the uncodified Hindu law, because in codified Hindu law we do not find any definition. So joint family is the group of lineal descendants of a common ancestors, including their wives and unmarried daughters. So again, we have to redefine that definition in the teeth of Act 39 of 2005. Then copartionary. Copartionary is the three male generations from the propositus. What do you mean by propositus? Can anybody say propositus? Yes, you are right, 100%. Suppose I sought for partition and I got a property from ancestral property in the partition. And I have son and grandson. So the property in my hands is ancestral property to my son and grandson, but it is not ancestral property to me. It is called copartionary property. So the propositus is the last person who acquires the property, ancestral property, either by way of filing a suit or by oral understanding in partition, and that man is known as propositus. And as far as that man is concerned, the property is called as copartionary. And in terms of its children, son and grandson, that property should be termed as ancestral property. This is the chief difference. And we go through Mullah or main Hindu law, we can find that ancestral property is a species of copartionary property, and they will give all plausible explanation to support their view. So, incidents of copartionary. So, incidents of copartionary, the first incident is the male generation, three male generations, including the propositus, that comes to 4. So, me, my son, my grandson, and my great-grandson are known as copartioners. But after the adventing of the Act 39 of 2005, we have to redefine the incidents of copartionary also. The first incident of copartionary again requires a redefinition because the daughter is also elevated to the status of a son. Now I would like to discuss the clashing views of Pulavati case, Danamma case, and Vineet Sharma case. In Pulavati case, they said that the act is not retrospective, the act is prospective. In Danamma case, they said that it is retrospective. In Vineet Sharma case, they said, anybody clue? Retroactive. Very good. What do you mean by retroactive? We had prospective, retrospective, but so far we didn't hear. Of course, as far as me is concerned, I didn't hear retroactive until I have gone through the definition, the judgment passed in Vineet Sharma case. It is a mini mullah. It is a mini mains. If you go through that judgment running 122 pages, you can understand all the ramifications relating to Hindu Succession Act and Indian Succession Act. Please go through all the pages. So, in Pulavati case, what happened is, and how our misunderstanding or misconception of the law would spell a disaster on the litigant public, I try to convince you. In Pulavati case, Pulavati filed a suit in the year 1992, that is OS 12 by 1992, on the file of civil judge senior division at Belgaum. Her contention is that her father had some self-acquired property and ancestral property, and he died leaving the brother and sisters. Her brother and sisters. The brother, Prakash, resisted the maintainability of the suit on the ground that Act 39 of 2005 has no application since she was not the daughter of a living co-partner because father died way back in the year 1988. And the suit was filed 4 years thereafter. And she is entitled for a share in the self-acquired property and not joint family property. Because after the death of the father in 1988, Section 6 comes into operation, and by virtue of national partition, there is a division of status and property is vested in the co-partners, that is the sons. So the daughter has no right whatsoever to claim a share in the joint family property or ancestral property or the co-partner property. The trial court rightly rejected the plea, holding that she is entitled for a share in the self-acquired property of her father, but she is not entitled for a share in the joint family property. Then she approached the High Court. High Court said that because Act 39 of 2005 came into force while the matter is pending before the trial court, as per the principle laid down by the Honorable Apex Court, in G. Shaker versus Geta, reported in 2009, Part 6, Supreme Court cases 1999, the development of any law, irrespective whether it is prospective or retrospective, is applicable and it would have impact on the matters tried by the trial courts and the high courts. So, she has a right in the property and the high court allowed the appeal and set aside the decree passed by the trial court. Then the unsuccessful party Prakash approached the Apex Court. There the Apex Court said that as seen from subsection 3 of section 6 and also section 6 and subsection 5 of section 6, on and from the commencement of the act, the paraphrase used the on and from the commencement of the act, and that's why the father was not there on the date of the enactment. When a co-partner dies, the daughter has equal right in the property on par with the son. But in this case, the father died in 1988, so that she cannot make any claim and she has no right. Moreover, there was a partition by virtue of national partition by virtue of explanation to section 6. And there is a division of status and it need not be required registration as per the explanation to section 6. Because the unsuccessful party took a plea that as per explanation to section 6 of the new amended act, there must be a registration or there must be a decree passed by a competent court. Till then, the daughter can ask for a partition. The Apex Court said that by virtue of section 6, that is national partition comes into play and it doesn't require any registration because it is a partition by operation of law. So that both the pleas were rejected and the appeal is allowed. Second appeal is allowed. And the judgment of the trial court is confirmed. That was decided in the month of October 2015. For 3 long years, the trial courts followed the judgment. There, in the year 2018, on 1st February 2018, Danama case came, pronounced by the same Apex Court, stating that, no, it is retrospective in nature, not prospective, it is retrospective in nature. Danama case, what happened is, Gurlingappa Savadi is the propositus. He died in the year 2001. Danamma and her siblings fought for property. Danamma filed a suit for partition. And the other side resisted the maintainability of the suit on the ground that she was born before 1956. Act came into force. So she is not entitled for any share. And secondly, they relied on the citation, Pulavati case. But after threadbare discussion, The trial court dismissed the suit. They preferred appeal to the High Court. High Court also dismissed the suit. They approached the Supreme Court. There the Supreme Court knew that as seen from the language employed in section 6, a Hindu woman is elevated to the status of a co-partner. It means that she has a right by birth. When she has a right by birth, the death or living of father is not the criterion to decide whether she is entitled for partition or not. So, she must be a living daughter of a living co-partner, which is the principle held in Pulvati case was not considered. And it was held in Dhanama case that because the intent of the legislature is to give a right by birth, and when her father died is not a matter to decide the case, and they delivered the judgment upholding the plea of Dhanama. But how sometimes a red herring, a possibility of red herring occurs, we must see. In Dhanama case, they discussed the Pulvati case. They extracted all the excerpts from right from 17 to 23. In para 22 of Dhanama case, they agreed with Dhanama, the Pulvati case, but they gave different opinion. Had they referred the judgment on that day itself in 2018, the things would have been different. But in 2020, some litigants have brought the matter to the notice of Apex Court and to the registry. Then all the matters pending by that time, about 11 matters, were clubbed together and a common judgment was passed in Vinit Sharma case, which is a landmark judgment, and I say that it is a watershed in the annals of Hindu Succession Act. Because they for the first time answered all the questions. You are saying that when national partition is worked out, properties are vested in the parties. When properties are vested in the parties, suppose the daughter files a suit 10 years after the enactment 39 of 2005 came into force, what about it? Or when there is no dispute at all and there is only one son and father died and he has been enjoying the property as a co-partner by that time, that is in the year 1980 to 2005, when the 2005 Act came into force, when the daughter taking advantage of the enactment files a suit, what would be the case? Because already property is vested in the lone son, sole son. How can the Act can divest that property? Then they said that it is neither prospective nor retrospective, it is retroactive. Retroactive means sometimes even the vested rights can be disturbed or new rights can be confirmed. That is the power of retroactiveness. So the Supreme Court brought into light the word retroactive first time while deciding the case law in Vinit Sharma and rendered the judgment. Then what are the differences? In Pulvati case, they said that to claim a share, the daughter must be a living daughter of living father. And she cannot claim a share unless the father is alive on 9/9/2005. That is on the date of commencement of the Act. So national partition, which is operation of law, need not be registered. These are the 3 points. Whereas in Vinit Sharma case, it was held by the Apex Court that because the scheme and object of the enactment is to give a right by birth to a woman and she is elevated to the status of a co-partner, irrespective of the death or living of father, she is entitled to claim a right in the co-partnership property. Secondly, that oral partition cannot be taken into consideration unless such partition is evinced by a public document or just like a decree passed by a court, the standard of proof is such, and in all other cases, oral partition should be straightaway rejected. So now when we take a plea, there is a oral partition unless you are sure in case of landed property that there are patta passbooks, 1B, number 3 adangal, supporting your contention for a long time, you cannot take the oral plea. And you have to file all those documents to show these are the public documents. Though the oral plea is prohibited by the apex court, there is an exception carved out by the apex court that when there are public documents supporting your oral plea, you can take that plea in the plate. So in all other cases, that plea should be straight away rejected. Next, what is the right of a widow? How many of you have gone through Tulsamma case? Sasha Reddy versus Tulsamma. So, what is the law laid down in that case? Are you aware of the facts of the case? Please.
ప్రాపర్టీ ఆ మెయింటెనెన్స్ కోసం ఇది చేస్తారు. మెయింటెనెన్స్ అనేది అది అమ్ముకోవడానికి కూడా ఫుల్ రైట్స్ కింద కన్వర్ట్ చేయొచ్చు అనేది
How come? Because subsection 2 of section 14 says that if the property is given to a woman
for maintenance
by way of will, gift, court decree or award, when there is a restriction and it is a restricted property, she cannot alienate it. Then how come the apex court explained it?
Section 14.
Section 14. Okay. You are right. Please, Arun, I will tell you. In what happened in Tulsamma case is, Tulsamma, a widow, filed a suit for maintenance, petition for maintenance against her brother-in-law, Sasha Reddy, who became the katta of the joint family after the death of his elder brother. That is the husband of Tulsamma. Then, while the suit was pending way back in the year 1960s, they entered into compromise, and as per the compromise, Sasha Reddy consented to enjoy the property during her lifetime, and thereafter it should be given to Sasha Reddy. And the court passed the decree as per the terms of compromise. Later, she alienated the property in contravention of the compromise and in contravention of the decree passed by the civil court. Then Sasha Reddy filed a suit for cancellation of the sale deeds relating to that immovable property. The trial court decreed the suit. The district court set aside the suit, decree, and allowed the appeal, stating that it falls within the ken of section 11 subsection, section 14 subsection 1, and it doesn't fall within the ken of section 2 subsection 4, section 14 of subsection 2. Then they went to our high court. Our high court confirmed the decree passed by the trial court and reversed the decree passed by the district judge. Then they went to Supreme Court. Tulsamma went to Supreme Court. There, several important propositions were brought into light. One is, Tulsamma's husband died prior to 1937. She has no right even for limited estate. When she has no right for limited estate, the question of enlarging that limited right into absolute right under subsection 1 of section 14 doesn't arise. And number 2 is, she agreed by filing a compromise petition to enjoy the property without right of alienation. So the decree passed by the civil court comes under the ambit of subsection 2 of section 14. So it is a restrictive right and she cannot violate it. Then the Supreme Court answered, under Sastric law, the old and uncodified Hindu law, the Karta of the family, because Sasha Reddy after the death of his elder brother has become the Karta of the family and he is obliged to maintain the widow, unmarried daughters and to perform the marriages of unmarried daughters in the joint family. So, Sastric law gives a right to the widow, though not, she has no right whatsoever in the year 1936 because her husband died even before 1937. Though not, she is not entitled for a limited right. So, under that proviso, she got a right of maintenance that can be considered as a pre-existing right. You go through section 14, explanation to section 1. What do you mean by Stridhan property and women estate? Can you give? Please. These are all and that's why I'm saying you must have some seamless blend of pragmatic and dogmatic knowledge. Unless you try to strike a balance in between these two, there is every possibility for red herring. Stridhan property is different from women estate. Women estate means a property which is devolved on her by way of partition or by way of inheritance. These are the two only. All other properties are Stridhan properties. Gifts given to her during marriage, property acquired by her, property gained by her by special skills, property acquired due to adverse possession under section 27 of Limitation Act. These are all and property acquired under compromise. There are 7 items whereunder they are classified as, enumerated as Stridhan property, and there are only 2 items which are classified as women estate. After the adventing of 1956 Act, the word women estate is repealed. Now whatever property is held by a woman is known as Stridhan property and you cannot use the word women estate. So, when she received the property in pre-recognition of her existing right under Sastric law and uncodified Hindu law as a maintenance, explanation to subsection 1 of section 14 clearly envisages that when a property is given in lieu of maintenance or in lieu of arrears of maintenance, that enlarges into absolute right. So, secondly, she has no right to property, but she has right against the property. Right to property is different from right against the property. Right to property, because 1937 Act, she is not a limited owner. 1956 Act doesn't apply, but she has right against the property because she has right of maintenance. That's why we must go through the entire judgment, leaving the plaster. And the second one is Bharat Mata case, in case of illegitimate children. Now it is the buzzword. How come the children born out of living relationship, whether they fall under the definition of legitimate or illegitimate children, or they do not fall under both the categories? In Bharat Mata case, what happened is, one Periya Ammal filed a suit claiming the property of her brother, who is unmarried, and the first defendant, Rangammal, claims that her brother, deceased brother, Muthu Reddy, had living relationship with her, and she had 2 children born to him, and that's why they are entitled for sharing the property. Then the plaintiff, Periya Ammal, claimed that she had earlier marriage and Alagar Swami Reddy is her husband. That marriage was not dissolved And that's why the children born even after consuming, after assuming for a moment that they are born to Muthu Reddy or her brother, they cannot be considered as either legitimate or illegitimate children. They are considered as that, which is prohibited. Law frowns on illegitimacy and law supports legitimacy. So you cannot use the words. In such a case, what is their status in the estimate of the public? So the trial court rightly dismissed this claim of the defendants and allowed the claim of the plaintiff. The matter went to High Court. High Court reversed it by taking shelter under the proviso of Section 114 of Indian Evidence Act, that long cohabitation as a wife and husband in the estimate of the public can be presumed as that there is a marriage and they are wife and husband to all intents and purposes. But Section 50 is the correct proviso, and then they went to Supreme Court. Supreme Court said that no, the High Court failed to consider the record, and it came to erroneous conclusion. In Kushubu case, we clearly held that unless the living relationship is in between two major unmarried persons, we cannot support the legitimacy or illegitimacy. As seen from Section 16 of Hindu Marriage Act, legitimacy means when the second marriage is void for the reason of due to the provisions of Section 11, because the first marriage is still in existence, then we can consider the children born to the second wife are illegitimate and they can claim property as if they are legitimate children. And the only exception is that they cannot claim partition during the lifetime of their father. That is it. And they cannot also claim share in the property of near and dear relatives of the parents, like legitimate children. So that raised the curtain for another dispute. In Ravan Siddhappa in 2011, they said that the enactment to Hindu Marriage Act Section 16 is a paradigm shift and a radical change is brought, and the law recognizes the illegitimate relationship or unlawful relationship in between the man and the woman, and the children cannot be bastardized on the ground that the mistake done by their parents. So after coming to know about the Bharat Mata case, they intelligently referred the matter to the larger bench. And the larger bench of late pronounced a judgment: illegitimate children are equally entitled to a share in the properties of parents, including the ancestral property. And the only damper thrown is that they are prohibited claiming property of near and dear relatives of the parents. But legitimate children can claim as reversionaries. That is the law established. And the second one is our decision by Honorable Justice Sitaramurthy Garu. Nagapatla Venkatachalam versus Nagapatla Saroja and others, reported in 2019 Part 6 ALT Division Bench, Honorable Justice Uma Devi and Honorable Justice Sitaramurthy. They said that the son claiming that his father died and he is entitled for compassionate appointment and approached the Honorable High Court. As seen from the voluminous record, there is no proof of marriage, and there is no proof of living relationship also. Then the Honorable High Court said that even considering all the pleas raised by the writ petitioner, that he is born to his mother and father who had living relationship, we cannot consider him as either legitimate or illegitimate children. Because to consider as a legitimate or illegitimate children, there must be second marriage. And the second marriage is void under section 11. Unless the second marriage is there, you cannot say that you are illegitimate children. And the writ petition is dismissed. But in latest decision, the Supreme Court made it clearer that when there is a living relationship, the children born out of living relationship, but the length of that living relationship must be considerably more. Under section 50 of Indian Evidence Act, that when a man and woman have been living together under one roof for a considerable period, and in the estimate of the society, they are treated as wife and husband, it can be deemed that there is a presumption of marriage because of long cohabitation, and the children born out of living relationship, they are considered as legitimate children. Recent decision, you know very well. Gentlemen, these are the views expressed by the Honorable Apex Court, and I request you to go through the commentaries, mullah or names, to have a comprehensive understanding about Hindu law. It is not that much easy subject. That is the reason why right from Tulsamma case to till today, 1977 to till today, we have been facing several red herrings in the trial courts, in the constitutional courts. So, whenever any matter came to you, you please go through for a partition, you please go through commentary and try to take averments as per law. Thank you very much for giving this opportunity. One sec. Just his lordship said that partition, have you heard about the word vovalty in a partition suit? Have you heard about the vovalty in a partition suit? Suppose there are two brothers, 90 cents is there, 92 cents are there. The elder brother claims 92 cents and the younger brother claims 90 cents, but you are also claiming 1 cent out of that. They are situated on either side of the road. Road kitupaka, road katupaka unnai. Videnti 92 cents had fallen to the share of my brother. 90 cents fall into my share. I am equally entitled. I want that one share, one cent of land. Then how the court can decide it? How the court can decide it? So, vovalty. So, just mere appearance, the court need not wait for the consent of the parties. He cannot give that 1 cent separately to the brother. Vovalty means compensation. So, by awarding compensation, you can silence the other party who has not given consent to retain that property, and that consent must be given, that the price must be decided as per the market value. This is vovalty under section 2 of Partition Act.
హిందూ చట్టం మీద చాలా చక్కని ఉపన్యాసం ఇచ్చారు. వివిధ అంశాల మీద వారు చర్చించే ఈ అంశాలు మనంతా వెరీ స్ఫూర్తిదాయకంగా ఉన్నాయి. ఇవన్నిటికీ కూడా మనం మననం చేసుకోవాలి. ఇప్పుడు మన చీఫ్ గెస్ట్ గారికి సన్మానం.
It is with great pleasure and respect and gratitude that I extend this word of thanks to Sri U. Satyarao Garu, sir. We are truly honored by your presence here today. Your vast experience, particularly in these laws, has left a lasting impact on the legal community in Visakhapatnam. On behalf of the Bar Council of Andhra Pradesh and Damodaram Sanjeevayya National Law University and all the participants, I express our sincere gratitude. Thank you, sir.
తెల్లవారి ఈ న్యాయశాస్త్రం మీద మధించి దానిని అవలోకించి దాన్ని ఆవాహించి అన్ని కార్యక్రమాలు చేసుకున్నాం. కావున రిలాక్సేషన్ కోసము సాయంకాలం 7:15 గంటకు మనకు మ్యూజికల్ పార్టీ ఉంది. ఆ తర్వాత చక్కటి విందు భోజనం ఉంది అక్కడనే. నేను దయచేసి మీకు చెప్పేది ఏమిటంటే, ఒకవేళ వాన కానీ పడిందంటే ఇక్కడనే మ్యూజికల్ పార్టీ ఉంటుంది. నిన్న మీరు ఎంత సంతోషపడ్డారో. తెల్లవారింటి జరిగిన దాన్ని నేను వదిలేయమని చెప్పడం లేదు, గాలిలో వదిలేయమని చెప్పడం లేదు. కొద్దిగా పక్కన పెట్టి ఈ న్యాయశాస్త్రాన్ని శరీరానికి మనసుకు ఒక ఉల్లాసాన్ని కలిగించేదానికి మనం వాకింగ్ చేయండి, మిగతా కార్యక్రమాలు చేయండి. థ్యాంక్ యూ.